Senkone Good morning, everyone. Hope everyone's doing well today.
Good morning, Your Honor.
Good
Good
morning,
morning,
Rod.
John.
Good morning, Your Honor.
Good morning.
Morning, Judge.
Let's see, I don't see anyone in courtroom 2 yet, and I don't see any other courtrooms on the line. So as soon as they get ready, we'll be ready to proceed. I have Melissa Grace in court with me today, so if you'll get your paperwork to her after court, she'll get it to me and we'll get it all signed. Yes.
Recommendations is right there where the calendar is right there because we
Okay.
didn't put them on the calendar.
Okay, thank you. And April is, we don't have anyone from the jail yet. Right, no one's in the court. Ms. Champion, are you there?
Yes, sir.
Would you check with the South Annex to see if they have anyone that's ready to go for me?
Yes, sir. I'll call out there.
Okay, thank you.
Good day yesterday, Judge.
All right, so until we get some positions, the court will be on recess. Good morning, Officer Norris. Are we ready to get started?
Good morning, Judge. Yes, I am, sir.
Okay, just let us know when you're ready.
We can start with Mr. McKeever. I didn't get the position number yet. McKeever.
Makita,
No. I'm sorry, Your Honor. Stinchcomb. I apologize. Stinchcomb. Come on up.
Your Honor, I'll be handling that case. Mr. Stinchcomb has 5 positions on the calendar.
and what are those numbers, Mr.
Uh,
Ford? Good morning.
On the regular, good morning, Your Honor. On the regular calendar, he's position 31.
Okay,
And on the add-on calendar, he's position 5 through 8.
okay, thank you. And what are we doing with Mr. Sitchcomb this morning?
Your Honor, on position 31, we have a non-negotiated plea. We want to deal with a NOLO and jail time issue. On the add-on calendar, positions 5 and 6 are negotiated. And positions 7 and 8, we're also dealing with a NOLO and jail time.
Okay, and good morning, Ms. Mitchell. Will you be presenting for the state on these cases and this, Mr.
Good
Sitchcomb?
morning, Your Honor. Yes, I will.
Okay, all right. Good morning, Mr. Sitchcomb. I'm Judge Eric Morrow. This is the state all-purpose calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard? Good morning. Do you agree to have your case heard by video?
Yes, sir.
Okay, thank you. Mr. Sitchcomb, can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can put your hand down. Thank you, sir. Let me go to pretrial first. Who do we have on from pretrial this morning? Hi, Ms. Harrison. Good morning.
Morning, Judge.
Can you give me the history, please?
1 moment. I'm showing 57 cycles in Georgia. Also, he has a history in California and Kansas. Last arrest. Was May of this year, and that was a failure to appear on a criminal trespass. He has a 2021 theft by shoplifting in Fulton County. That was a misdemeanor conviction. A one moment. He has a 2018 criminal trespass and false report of a crime in Fulton County, misdemeanors, convictions. He has over 5 violations of probation within the past 5 years. And prior to that, 2017 criminal trespass and conviction out of DeKalb. And a 2013 possession of marijuana less than an ounce. College Park, a 2012 reckless conduct out of Clayton County, nothing further.
Okay, thank you, Ms. Harrison. Ms. Mitchell, would you start with, I guess, position 31, it's on the state all-purpose calendar, and then
Oh.
move to the add-on calendar, I guess.
Okay, will do. For the add-on calendar, would you like me to just address the position 7 and 8, the one that's non-negotiated?
Yes, and position 31 is not negotiated either, is it?
Correct.
Okay, all right, yes,
Yeah.
go ahead.
We'll start there. Okay. Your Honor, for position 31, the state's plea recommendation is 12 months to serve, 60 days, credit for time served, 15 days, balance probated, theft prevention service, theft prevention course, 40 hours community service, and no alcohol, drugs, and weapons. Your Honor, in this case, the defendant ordered a beer at Ruby Tuesdays at 1230 Virginia Avenue and ordered that beer without paying for it. When provided the check, he teared it up and crumpled it. Instead, he asked the customer next to him to pay for it. Your Honor, as heard from pretrial, the defendant does have an extensive history. I had to go through case manager just to find the convictions because his history was so deep. But as far as his conviction goes, he has a criminal trespass and public intoxication conviction in 2021, public drunkenness conviction 2019, public drunkenness, pedestrian under the influence in 2021, criminal trespass 2021, again, pedestrian under the influence and in the roadway 2021, obstruction, public drunkenness, criminal trespass 2021, criminal trespass, public drunkenness 2020, public drunkenness 2020. Again, you can start to see the pattern. So in this case, we are objecting to the NOLO based on his history. And as far as jail time is concerned, we are also objecting to that. We're requesting the 60 days on all 3 cases due to his history and the fact that he has these 5 open cases that we're handling today. So we will be objecting to that. Moving on to the add-on calendar position 7. In this case, the defendant urinated on the floor of CVS located at 2907 Main Street, East Point, Georgia. The defendant then left the store and stood on the sidewalk. When officers made contact with the defendant, they were unable to understand that what he was saying. The defendant had a strong odor of alcohol coming from his person. There's also security footage from CVS of the defendant urinating inside the store on the floor in front of the pharmacy. In this case, the state's plea recommendation is 12 months to serve 60 days, credit for time served 15 days, balance probated, to stay away from that CVS, ADET, and no alcohol, drugs, and weapons. Again, we're objecting to the NOLO and jail time at issue. Moving on to position 8. In that case, the defendant, Your Honor, it's hard for me to get into the facts of that due to the nature of those allegations. Not sure. How would you like me to handle that? Well, I can go ahead and put the plea recommendation
Okay,
on
go ahead.
record. 12, that will be 12 months to serve, 60 days, credit for time served, 15 days, balance probated, a stay away from the Shell gas station located on 751 North Central Avenue, Hateville, Georgia, at ADET, no alcohol, drugs, and weapons. I also need to add the stay away to position 31. I don't believe I stated that to the Ruby Tuesday. And all of these will run concurrent with each other.
Okay. Do you know where that Ruby Tuesdays is located?
Yes. Position 31. That will be 1230 Virginia Avenue.
Okay. Thank you, Ms. Mitchell. Mr. Ford?
Thank you, Your Honor. What was that, 1230 Virginia?
Yes.
And Ms. Mitchell, what's your first name?
Mariah.
Mariah. I only asked because we have to put that on the form, the plea form. So I just want to have your complete name. Your Honor, we're asking for time served on all of Mr. Stinchcom's charges. He's 62 years old, Your Honor. He is homeless. His only source of income is SSI. Prior to his condition that he's in now, he has a bachelor's degree in health and physical fitness from North Carolina A&T, Your Honor. And this is not, he has no violent crimes, Your Honor. I mean, he has some things that we don't condone, things that have happened in his life, but he has had no violent history where he's been assaultive, where he's had issues with other individuals directly. These are crimes of basically survival, and also crimes of having a medical illness, of possibly having some type of substance abuse issue. But Your Honor, I don't think jail is the place for Mr. Stinchcomb at this time. I think that better fit is for him to be out looking for a place to live, looking for some type of way other than his SSI for employment, and that cannot happen while he's incarcerated, Your Honor. He's a lifetime, even though I know this is not a bond hearing, but just to let you know about Mr. Stinchcomb, he's a lifetime resident of Georgia, 62 years. And as I mentioned, he has had no violent crimes or assaultive attacks on anyone. He does have support here in the area. He's given me his sister's name and telephone number, so he does have that. He wants to get back on track, Your Honor. I think he spent the last 16 days incarcerated. He needs to be out there trying to use his bachelor's degree, trying to use the funds that he does have to get suitable employment, suitable place to live. And at this point, Your Honor, I think if you look at position 31, theft by services, once again, it's a survival situation. He asked for somebody to pay for his beer, which I believe, if you look at what's going on in society, people are asking for things like that each and every day. In positions 5 and 6, we've negotiated, because those are time served. 7 and 8 on the add-on calendar, Your Honor, if you take a look at those particular crimes, one is, I'm not going to sound out 8, except for the one count of criminal trespass, Your Honor, and the other one's criminal trespass and public drunkenness. He's spent 62 years in Georgia, and he's only person he's really harmed, Your Honor, is himself. And so I think this is a chance for him at the age of 62 to get back on track, to find a place to stay. I did suggest Gateway. I do have the information for him if he chooses to go there, but I don't think any further incarceration is necessary, Your Honor. So we're asking for time served and NOLO on position 31. I know he only can use one every 5 years. I don't believe he's used one. And the other ones, we'd like to have a NOLO, but on position 7 and 8, if we choose not to give him a NOLO, we'd like to have at least one NOLO at this time. He's prepared to plead guilty to add on 7 and 8, Your Honor. So we're asking for time served and a NOLO plea.
Okay. Have you already sent a social worker out to speak with Mr. Stitchcomb? Do you know, Mr. Ford?
No, we haven't, I haven't had a social worker go out to see Mr. Stinchcomb. Mr. Stinchcomb is very aware of what he needs to do. He knows exactly where Georgia Works is. I believe this is a program that he can take full advantage of. I think he's a great candidate for that. Like I said, he's welcome to go there, but he does have some income. He does have a sister that he can lean on for support as well. So, Your Honor, that's why we're asking for no jail time at this, no further jail time at this time.
Well, I'm concerned mostly about housing. If he doesn't have housing, then he may not be able to complete the terms of the probation, and then he'll be right back where he is. So I don't want to set him up for failure in that regard. So if you tell me that he has a place that he can go to and reside, or at least, get some housing, I think that would be helpful for him.
Yeah, it would be, Your Honor, and that's what I was going to talk about next too, because in Mr. Stinchcomb, he cannot afford the 40 hours of community service and the theft prevention class. I think if he does go to a program like Gateway, they do provide certain services, help him get employment. So we're asking for those items not to take place, that he does not have to do the 40 hours of community service, and that his probation fees be waived at this time. Mr. Stinchcomb, I just want to ask a question. You know where Georgia Works is, am I correct?
Georgia Work?
Yes.
Yes, sir.
Gateway. We
Yes, sir.
talked about that. You
Yes,
need to, once you release from here, no matter what happens, we talked about you going directly there. Am I correct?
Correct, sir.
Okay, so, Your Honor, I don't think social workers need, I think the Georgia Works program is a very good fit for Mr. Stinchcomb at this time.
Okay. Mr. Ford, given his history, I'm not going to allow him to use a NOLO, but I will take into consideration the rest of your argument, okay?
Thank you, Your Honor.
All right. Do you need to speak with him about that?
About what? We did talk about that. Mr. Stinchcomb, you will not be able to use the NOLO, but the judge is going to take into consideration all the other issues we talked about. Is that okay?
Yes, sir.
All right.
Okay. Anything further, counsel?
Nothing, Your Honor.
Mr. Stitchcomb, it's my understanding that in case 22 CR 003314B, that you wish to plead guilty to theft of services, and the add-on state all-purpose calendar, position 5, 21 CR 006367A, you wish to plead guilty to public drunkenness, and position 6 on the add-on calendar, case 21 CR 006392A, you wish to plead guilty to public drunkenness, position 7 on the add-on calendar, case 21 CR 006424A, you wish to plead guilty to criminal trespass and public drunkenness, and on position 8 on the add-on calendar, you wish to plead guilty in case 21 CR 007190A to one misdemeanor offense and criminal trespass. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
No, Your Honor.
You've been represented by counsel. Are you satisfied with your counsel's representation?
Yes, I am.
You understand that you have a right to a trial by jury on these charges, and that by pleading guilty to them, you're giving up your right to a trial by jury?
Yes, Your Honor.
Has anyone forced or coerced you to plead guilty?
No.
I will accept your guilty pleas, Mr. Stitchcomb. In position 31 on the state all-purpose calendar, case 22 CR 003314B. The sentence will be 12 months to serve 30 days, credit for time served, 30 days. Balance suspended, stay away from the Ruby Tuesdays at 1230 Virginia Avenue. No drugs, alcohol, or weapons while out on bond. In position 5 on the add-on calendar, case 21 CR 006367A. The sentence for the public drunkenness would be 12 months to serve 30 days, credit for time served 15 days, balance suspended. On position 6 on the add-on calendar, 21 CR 006392A, public drunkenness. The sentence would be 12 months to serve 30 days, credit for time served 15 days, balance suspended. On position 7 on the add-on calendar, 21 CR 006424A, criminal trespass and public drunkenness. The sentence will be 12 months to serve 30 days, credit for time served 15 days, balance probated. Alcohol drug evaluation and treatment if necessary. No drugs, alcohol, or weapons while out on bond, and stay away from the CVS. We'll get the location of that CVS for you. In position number 8, 21 CR 007190A. The one misdemeanor offense and the criminal trespass. The sentence will be 12 months to serve 30 days, credit for time served 15 days, balance probated, alcohol drug evaluation and treatment, no drugs, alcohol, or weapons while out on bond, and stay away from the Shell gas station. I'm going to waive the probation fees for you while you're on probation to help you get and stay on your feet, but I'm going to require that you be on probation for the entire 12 months. All of these cases will run concurrent. Okay, any questions regarding that, Mr. Ford or Ms. Mitchell?
No, Your Honor.
Your Honor, is there any way for that to be a non-reporting probation?
I would prefer, given that he's not going to have to do any additional jail time, and that he may have some problems with, and it appears that he might with alcohol, that I prefer that he be on reporting probation for the 12 months, but I will waive the fees for him.
All right, Your Honor.
Okay. If nothing further on Mr. Stitchman, good luck to you, Mr. Stitchman.
Good morning. Have position number
Ms. Mitchell.
33, Mr. Thomas.
I've got down that this is also non-negotiated, Mr. Ford.
That's correct, Your Honor. I'm going to find it here in a minute. What position is that, 33?
Yes, sir.
Yes.
Thank you. That helps. All right. Yes, Your Honor, this is non-negotiated, position 33. The issues are NOLO, community service, anger management, and jail time, Your Honor.
All right. Good morning, Mr. Thomas. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video? Okay. Is Mr. Thomas in courtroom too?
He's on 4 North.
Oh, 4 North. Okay, thank you. Did you hear my question, Mr. Thomas?
Yes, Your Honor.
Okay, and you agree to have your case heard by video?
Yes, Your Honor.
Okay, thank you. Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you. You can put your hand down, sir. Ms. Harrison, what's the history, please?
Yes, Your Honor. 11 cycles. Last arrest was October of 2019 for escape in Fulton County. No disposition listed on that arrest. Record does indicate a 2020 open probation, 19 SC 172430, sentenced May of 2020. 1 year confinement and 4 years probation.
What were the charges?
I'm sorry, aggravated assault. And one moment. A 2019 given false name to officers, that's a misdemeanor conviction. One second. There is a 2018 battery family violence. It was transferred to Superior Court, no disposition listed on that arrest. A 2014 burglary, second degree with intent to commit theft, no disposition listed, and a 2013 felony conviction for robbery. He received 4 years probation, 1 year confinement. Nothing further to add.
Okay, thank you. Ms. Mitchell?
Yes, Your Honor, the state is recommending 12 months to serve 90 days, credit for time served 14 days, balance probated, no further contact with Michaela, spelled Makayla, White, a stay away from MARTA, 12-week anger management, SDET, 80 hours community service, and no alcohol, drugs, and weapons. Your Honor, in this case, the defendant battered Ms. White while on the platform at 5 Points MARTA station by striking her in the face, leaving a bruise on the side of her cheek. I won't sound on the facts in regards to count 2, but this incident started when Ms. White got off the train. The defendant tried to have a conversation with her, but she kept walking off. The defendant attempted to hug her, but when she said no, he got upset and then proceeded with the facts as to count 2. When officers went to detain the defendant, he ran away in an attempt to flee. Your Honor, the defendant is a convicted felon with a violent history. He does have violent convictions as heard from pretrial of aggravated assault, family violence, possession of a knife, and battery family violence in 2019. He's also convicted of escape and giving false info and obstruction in 2019, and robbery in 2013, where he pled under First Offender Act. The defendant also has several violent charges. He has a battery arrest in 2018, a battery family violence arrest in 2017, and simple battery in 2015, and simple battery in 2014. And I'm just highlighting the relevant violent charges. It also appears that he has 2 outstanding warrants, one out of Atlanta for probation violation and one out of Decatur for FTA. So based on that, we are going to object to the NOLO based on his history. We're also going to object to no community service, anger management, and jail time, being that we do believe it is necessary in this situation, as he's shown in his history, that he does have AM issues and violent tendencies. So based on that, we are recommending our plea recommendation, Your Honor.
Thank you, Ms. Mitchell. Mr. Ford?
Thank you, Your Honor. Your Honor, could I ask Ms. Harrison a question about the aggravated assault? Was there a disposition on that case?
He's on probation.
Okay. Your Honor, my client, even though he does have some cycles and some issues that have come up based on his criminal record, Your Honor, he's paid his debt. You know, when you go to 4 years of probation and you have 1 year of confinement, you've actually paid your debt to society. To the point where, Your Honor, the reason we're asking for time served is due to the fact that he is employed at American Mart as a janitor. He has a secure job at this point, Your Honor, that he's in the process of possibly losing with the confinement that is being recommended by the solicitor's office. Mr. Mr. Thomas is a lifetime resident, and I say that because he does have roots, deep roots here in Georgia. He's also given me the telephone number and name of his fiance. He is working to get his life on track, do the right thing, Your Honor. And one of the things that I recognized when I did go to interview Mr. Thomas, I do ask the question of, do you have any children? And he was very happy to say that he had a 7-year-old daughter, and that I saw a glimmer, a real light shone in his eyes. Your Honor, I do have a stable address for him, stable telephone number, email address. Yes, there might be some things in his history that may show that he had some things prior, but I think at the age of 27, he's turning the corner. And I think to help him turn the corner, Your Honor, I think keeping his job would be something that would be, I think, very important, so he could help support his fiance and his child. So at this point, Your Honor, based on the things that have happened in his life, and I think how he's actually trying to make sure he's doing better, we're asking for time served so he can keep his job. We're also looking at the fact that I really think that 12 weeks of anger management on top of doing 80 hours of community service would definitely hinder him getting to work. He's got a job, he's making some money, but paying for 12 weeks of anger management, also looking at the cost of trying to do 80 hours of community service, I believe, Your Honor, is excessive for this case. So at this point, Your Honor, we're asking that the anger management weeks be reduced to 4. We're asking that the 80 hours of community service be reduced to 20. I believe those issues, those changes, Your Honor, will be manageable for Mr. Thomas. And also we're asking for time served due to the fact that I believe the job is very important to him at this point, and I believe he should, to be a good benefit to society, he should stay employed. So, Your Honor, we're asking for time served, reduction of anger management to 4 weeks, and also a reduction in the community service to 20 hours.
Mr. Ford, given his history and the nature of these charges, I agree with the state's recommendation, and that will be the sentence imposed if he wishes to plead guilty.
That's the 90 days, Your Honor. Did you hear that?
The entirety of the state's recommendation.
Okay. Mr. Thomas, did you hear that? We talked about your jail time. That will be about 31 more days of jail time, and you'd have to do 12 weeks of anger management and also the complete 80 hours of community service. Are you in agreement to that?
Yes, sir.
Is that a yes?
Yeah.
Yes, he's in agreement to that, Your Honor.
Okay. And let me make sure that I've sworn him in. Can you raise your right hand, Mr. Thomas? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, you can put your hand down. Thank you, Mr. Thomas. You've been charged in case 22 CR 003446G with battery, a second misdemeanor offense, and willful obstruction of a law enforcement officer. It's my understanding that you wish to plead guilty to those charges. Is that correct?
Yes, Your Honor.
Are you under the influence of any drugs or alcohol at the present time?
No.
You've been represented by counsel. Are you satisfied with your counsel's representation?
Yes, Your Honor.
You understand that you have a right to a trial by jury on these charges, and that by pleading guilty to them, you're giving up your right to a trial by jury?
Yes.
Has anyone forced or coerced you to plead guilty?
No.
I'll accept your guilty plea, Mr. Thomas. The sentence will be 12 months to serve 90 days, credit for time served 14 days, balance probated. No further contact with Ms. White. Stay away from MARTA, 12 weeks anger management, SDET, 80 hours of community service, and no alcohol, drugs, or weapons while out on bond. I'm going to waive your fees for you while you're on probation, Mr. Thomas, to help you get and stay on your feet, but you're going to have to be on reporting probation for the entire term. Good luck to you, sir.
All right, next, we got position number 10 and add-on 4, Mr. Connor. Connor.
10 and add-on 4.
And these are going to be arraigned in a bond hearing, Judge.
Okay. Good morning, Mr. Connor. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
No.
What was it? What was the answer?
Yes.
Okay, thank you. Can you raise your right hand for me, Mr. Connor? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you. Mr. Connor, you've been charged in case 22 CR 003410Y with battery, family violence, cruelty to children in the 3rd degree, and a second charge of battery, family violence. You've been charged in case 20 CR 005925Y with simple battery, family violence. Each of these charges carries with it a maximum penalty of 12 months in jail and or $1,000 fine. Do you waive formal reading of the accusations, Mr. Finley?
I do, Judge.
Mr. Connor, how do you plead to these charges? Guilty or not guilty?
Not guilty.
We'll record your not guilty plea. Your case will be returned to the division judge and you will get notification of your next hearing date. Do we have those bonds, Ms. Graves? Okay, so for position number 10, I have that for the battery, family violence, he has a cash bond of $2,000. For the cruelty, a cash bond of $1,000, and for the second battery, family violence, a cash bond of $2,000, which makes a total of a $2,000 cash bond that was set on May 31st. Do we know what his bond amount is on the add-on position number 4, Mr. Finley?
Yes, Judge. I believe altogether it's $5,000 combined between all of them. So
well, it can't be all 5,000 combined for all of them because just on position 10, it's 5,000.
Your Honor, I see
apologize.
that, I'm sorry.
I apologize. Go ahead, Ms. Tortorella.
I was gonna say, I see that the bond amount for the add-on case is $5,000 and it's a surety bond.
Okay, thank you.
I apologize. Yeah. Thank you.
That's all right. That's fine. I just wanted to make sure, Mr. Finley. Let's see. What is the history, Ms. Harrison?
18 cycles with history in Georgia, North Carolina, and Mississippi. Last arrest was December of 2020 for battery in Fulton County. That is currently position 4. Record does indicate the defendant is on probation in Clayton County for robbery and fleeing or attempting to elude police officers. Case number 14 CR 01457. Sentenced January of 2015, 3 years confinement and 7 years probation. Additional open probation in DeKalb for forgery, case 20 CR 1507. Sentenced December of 2021 with 2 years probation. Also, he has one moment. He has 3 violations of probation, 2 failure to appear within the past 10 years, and a 2014 misdemeanor conviction in Clayton County for simple assault, a 2014 robbery in Clayton. Nothing further to add.
Okay. Mr. Finley?
Yes, Judge. As we heard on position number 10, it is a $5,000 total cash bond. Mr. Connor is a proud father. I understand obviously these charges, but he has 2 children. He is active in both of their lives and does pay child support. He was recently on the waiting list and finally got into a fatherhood program, which is they help convicted felons find employment, find housing, and make money so they can help support their children, which he was on the waiting list for months and finally got accepted. And he eventually got a job at Solaris Amphitheater, where he's in charge of the operations of the concession stand. I did speak with Ms. Santana, and we are also addressing the no further contact. She did state that she is not afraid of Mr. Connor, that he plays a big part in her life. They've been together for 6 years. They're both from out of state, and pretty much she really stressed that they only have each other. But I did speak with Mr. Connor, and he said if he gets out, he can find somewhere else to stay if need be. And I told him obviously to get that address to the court and really stress the importance of him returning to court. So we are asking, or I am asking for number 10, a $10,000 surety bond on position 10, Judge.
So basically you're asking for the cash bonds to be doubled and converted to a surety bond.
Or if, I mean,
so right now it's 5,000 broken down to 1.2. So what you're asking for.
So I guess I'll revise that and do a if it can be converted into a surety bond, a $5,000 surety bond.
Okay. And you do understand that the requirements on the present bond are an ankle monitor, FVIP and ADET, third party to get belongings, stay away, and no further contact. Were you aware of that?
I would, okay, yeah, he's aware of that. I did not see that before, Judge.
Okay, well, I'm just reading from the
Yeah.
May 31st bond order from Judge Law.
Yeah, so not trying to flip flop on you, but I can go with a 10,000 surety if that's would be more likely for your honor.
Anything further, Mr. Finley, before I go to Ms. Tortorella?
Further, Judge, thank you.
Okay, Ms. Tortorella.
Yes, Your Honor. So the state's recommending that the $5,000 cash bond remain the same with the same conditions, and that he'd wear an ankle monitor as it is required and stated on the jail screen in Odyssey. Your Honor, there's proof the defendant will intimidate the victim and fail to come to court and reoffend while he's out on bond. The defendant has an open simple battery family violence case against the same victim, Santana Ballard, 20 CR 005925Y, where on December 6, 2020, the victim was trying to leave the residence and the defendant kept grabbing and pulling her back into the residence, and he struck the victim on the face twice with an open hand. He was granted a $5,000 surety bond where he was ordered to have no violent contact with his wife, Ms. Santana Ballard. Currently, he's in violation of that bond order due to the subsequent offense against Ms. Ballard, which is this case, 22 CR 003410Y. If there's no resolution today on the SAP calendar, Your Honor, the state will move to revoke the bond on the 20 CR 005925Y case. The defendant has an active charge of Warren County where Clayton County has a hold on him. There's no bond for this charge. And Rankin County also has a hold on this defendant for fugitive from justice and being held for this charge with no bond. So even if he does make bond, Your Honor, he has two holds against him. And as far as this case, Your Honor, on May 30th, 2022, investigator Armin Trout of the College Park Police Department responded to 2601 Roosevelt Highway, apartment G8 in College Park. Upon arrival, the investigator spoke to Mr. Elijah Richard, who was witness to the battery. He said he was upstairs when he heard yelling and screaming.
Mr. Richard ran downstairs and witnessed the defendant, Mr. Michael Connor, on top of his mother, the victim Santana Ballard. He observed the defendant had his hands around Ms. Ballard's neck, choking her, and he used physical force to pull the defendant off of his mother. And then Mr. Richards said the accused struck him several times with a closed fist, got on top of him, and then choked him as well. So we not only have concerns for the victim, Your Honor, we also have concerns for public safety. The defendant is a multi-state offender. You've heard his background. He pled to simple assault in Clayton County Superior Court on January 12th, 2015. His most recent arrest was actually in 2021 in Mississippi for carrying a concealed weapon, which is a felony. He was arrested by Pearl Police Department in Mississippi, and this case actually appears to be open. He has several violations of probations on his history and an FTA out of Clayton County in 2014. We understand that Ms. Ballard wants contact, but the state is strongly opposing that contact, Your Honor, and we, again, are asking for no contact, and that this bond, the $5,000 cash bond, and for the other case, the $5,000 surety bond remain the same. Nothing further.
Okay.
And,
Go ahead,
yeah,
Mr. Finley.
Sorry, Judge. I just wanted to say, I know Miss Santana really stressed she wanted to speak on his behalf. I believe she is on the Zoom, so she wanted me to make sure I said that.
Okay. It's Santana Ballard, is that correct?
That's correct, Judge.
If Ms. Ballard's on the line and would like to address this matter, she will have to unmute herself and I'll have to swear her in. And you'll have to activate your camera, Ms. Ballard. All right, Ms. Ballard, can you hear me? If you want to speak, now is your opportunity. Okay, so Ms. Ballard, what you're gonna have to do for me is you're gonna have to get in a stable place. I don't want you walking around, okay? And at this point, I can't hear you. Can you speak?
Yes, sir.
All right. Can you activate your camera and speak at the same time?
Sure. Okay, I think I got it.
All right, raise your right hand for me. Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can put your hand down. What would you like to tell the court, ma'am?
I understand everything that the solicitor is saying, but it's not that bad like she's saying it. The first situation, when he was charged, he really didn't put his hands on me. My kids just called the police because they heard a lot of screaming and hollering. So I was in the process of trying to find out how could I stop those charges. But other than that, he's a good father and he take care of this household. So now I'm in a situation of trying to pay my rent and stuff like that. And I don't know, I just need for him to take care of all his business. He don't need to be sitting in jail just on one charge when he got several other things going on.
Well, he also doesn't need to be laying his hands on you, does he, Ms. Ballard? And you don't need to be calling the police regarding that. He was given a stay away from you back in 2020. Apparently, he violated that stay away. He came back, and there are allegations that he did something similar again. Are you disputing that?
I told the lady that it was impossible for him to stay away when she called me because we had a newborn baby. And he helped take care of that baby, like babysit the kid while we go to work and all that. It's like, I told them that was impossible. I'm from Louisiana. I don't have no family down here.
All right. Thank you, ma'am. Anything further?
No, sir.
Okay. Based on everything I've heard, he's got bigger fish to fry. Even if I do lower the bonds, he has other things that will be holding him in. Mr. Finland, if he's able to deal with those other things and get bonds on those other cases, you can certainly bring him back here, and I will have a hearing for modification of the bond at that time. Okay.
Understood, Judge. Thank you.
All right. Good luck to you, sir. Who do we have next?
We got position 14 in medical, position 14.
Okay, thank you.
And judges, this will just be an arraignment.
Good morning, Mr. Gilliard. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Can you raise your right hand for me? Do you swear or affirm the testimony you're about to give before this court will be the truth, the whole truth, and nothing but the truth?
Sir.
Okay, you can put your hand down. Who's on for the state?
That's ASG Tortorello, Your Honor.
Ms. Tortorello, how many theft by receiving stolen properties is he being charged with? Do you know? I mean, there's so many that I can't count them.
Yes, Your Honor, it's 23 counts of theft
23.
by receiving and then 1 count of obstruction. So a total of 24 counts, Your Honor.
Okay, thank you. I appreciate that. Mr. Gilliard, you've been charged in case 21 CR 003153J with obstruction of a law enforcement officer and 23 counts of theft by receiving stolen property. Each of these charges carries with it a maximum penalty of 12 months in jail and or $1,000 fine. Do you waive formal reading of the accusation, Mr. Finley?
I do.
How do you plead to these charges, Mr. Gilliard? Guilty or not guilty?
Not guilty.
We'll record your not guilty plea. Your case will be returned to the division judge and you'll get notification of your next hearing date. Good luck to you, sir.
All right, next case is position 15.
Okay. Okay, Mr. Finley, this is going to be non-negotiated.
That's correct, Judge.
Good morning, Mr. Greer. I'm Judge Eric Morrow. This is the state all-purpose calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Can you raise your right hand for me? Do you swear or affirm the testimony you're about to give before this court will be the truth, the whole truth, and nothing but the truth?
I do.
Okay, you can put your hand down. Thank you, Mr. Greer. Ms. Tortorella?
Yes, Your Honor. The state's recommending for the theft by shoplifting, 12 months to serve 13 days, credit for time served 13 days, balance probated, a $500 fine, which cannot be suspended or probated per statute, 40 hours of community service, and a restitution amount of $18.69. For the obstruction, 12 months to serve 13 days, credit for time served 13 days, balance probated, a $300 fine suspended, and the obstruction runs concurrent with the theft by shoplifting. State's reasoning as far as the $500 fine is he's been convicted of a theft by shoplifting before. On September 21st, 2018, he was convicted of theft by shoplifting in Bibb County State Court. So for that reason, Your Honor, we are asking for that $500 fine. As far as the facts of this case, Your Honor, on May 28th, 2022, an Officer C. Lowe of the Atlanta Police Department responded to the Great American Cookie Store at 250 Park Avenue Northwest in Atlanta due to a shoplifting call. Upon arrival, the officer met with the complainant, Alexis Dunton, who said an unruly homeless man entered the store and grabbed several cookies from behind the counter. Ms. Dunton said the male suspect left the location without paying for the items. Ms. Dunton said that after the suspect took the cookies valued at $18.69, she videotaped the suspect fleeing the location and notified Mr. Leonard Washington, her child's father, who was in the area. The officer reviews Ms. Dunton's video footage and then met with Mr. Washington at the intersection of Olympic Park Drive and North Park Drive, where Mr. Washington pointed in the direction of the BP gas station at 610 Spring Street Northwest. The officer located the suspect in the parking lot of the BP gas station. The officer attempted to stop the suspect, later identified as defendant Anthony Greer, who fled on foot from the officer. After a brief chase, the officer was able to grab the defendant, put him on the ground, and the defendant continued to posture up and struggle with the officer and the officer's partner. The officer's partner deployed the taser on the middle of the defendant's back to gain compliance. The defendant was arrested, and all these events did occur in Fulton County, Georgia. Nothing further, Your Honor.
Are you asking for restitution?
Of $18.69.
And what about a stay away?
Yes, Your Honor, and I would have to add that, so stay away from the incident location.
Is that 610 Spring Street?
Yes, Great American Cookie Store is 250 Park Avenue West, Northwest in Atlanta.
Okay, thank you. Mr.
Thank you.
Finley?
Yes, Judge. I am asking for the fine and the restitution to be taken off on behalf of Mr. Greer. First, want to address the $500 fine. Mr. Greer has now been in jail on a $1,000 surety bond, which through a bonding company would be $100, which he's been unable to pay the $100. So I think it's safe to say he'd be unable to pay the $500. This case does derive from Mr. Greer taking 4 sandwich cookies with cream in the middle from the store. Those is what the charge revolves around. He clearly would not be able to pay that $500 fine, Judge. And additionally, once he does, we are okay with the community service, and once he completes the community service, Judge, asking that the probation either be suspended or be non-reporting.
So you're asking that he not have to pay the $500 fine, but
He can.
do want him to do the 40 hours of community service
I'm
and
okay
pay
with
the
community
rest
service.
and pay the restitution of $869. Is that right?
If he has to pay the restitution, that would be fine. I'm most concerned about the $500 fine that he just would completely be unable to pay.
And do you have an argument in regards to what Ms. Tortorello said, that the fine could not be suspended?
No, I understand. And if that's the case, I was unaware that it's statutory. If it's statutory, then obviously I understand. But that's why I originally addressed that.
Okay, would if the Ms. Tortorello, the state doesn't have an objection, if he's having trouble with the fine, I could convert that to 50 more hours of community service, which would make it 90 hours of community service.
I believe Mr. Greer. Mr. Greer, does that sound good?
Yes, sir.
Okay, so if we could do that, that would be great.
Ms. Tortorello, do you have an objection to that?
That's up to Your Honor, or I would suggest giving what the statute states, maybe amend it to a theft by taking. I could do that.
Okay, so. All right, so the state is amenable to amending it to a theft by taking and willful obstruction. As such, it'll be 12 months to serve 13 days, credit for time served 13 days, balance probated, 90 hours of community service, and restitution in the amount of $1869, along with the stay away. Is that agreeable with everyone?
Yes, sir.
Yes, sir.
Ms. Tortorello?
Yes, Your Honor.
Okay, so this will go from a non-negotiated to a negotiated plea. All right, anything further before I take the plea?
Nothing further.
Nothing
All right.
further.
Mr. Greer, it's my understanding that in case 22 CR 003388B, that you wish to plead guilty to theft by taking and obstruction of a law enforcement officer. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol at the present time?
Oh, sir.
You can represent it by counsel. Are you satisfied with your counsel's representation?
Yes, sir.
You understand that you have a right to a trial by jury on these charges, and that by pleading guilty to them, you're giving up your right to a trial by jury?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
I'll accept the plea as negotiated, Mr. Greer. I'm going to waive the fees for you while you're on probation to help you get and stay on your feet. And as soon as you do the community service and pay back the 1869, the probation will terminate, okay?
Yes, sir.
All right, good luck to you, Mr. Greer.
Yes, sir. Your Honor, going back to courtroom 2, we have
Okay.
position number 8, Mr. Willie Coleman.
This is a negotiated plea, Mr. Finley.
Mr. Coleman is a bond hearing judge.
Oh, okay, thank you. Good morning, Mr. Coleman. I'm Judge Eric Morrow. This is the state all-purpose calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Thank you. You can put your hand down. Thank you, Mr. Coleman. You've been charged in case 21 CR 001729E with battery. This charge carries with it a maximum penalty of 12 months in jail and or $1,000 fine. Do you waive formal reading of the accusation, Mr. Penley?
I do.
How do you plead, Mr. Coleman, guilty or not guilty?
I plead not guilty to the charge, sir.
Okay, we'll record your not guilty plea, Mr. Coleman. Your case will be returned to the division judge, and you will get notification of your next hearing date. Do we have his bond?
Your Honor, it's a $2,000 surety bond.
Is that? Did he, was this, he initially was given a SOB through pretrial per the judge. And did he violate that bond at some point?
It appears so, Your Honor. He was issued a bench warrant afterward by Judge Morrison with a $2,000 surety bond.
Okay, so he missed court in Judge Morrison's courtroom for some reason.
And twice at the Apollo calendar, 6/28/21 Apollo calendar and 10/4/2021 in the Apollo calendar. He failed to appear.
Okay, and you know what I do in cases like this, Mr. Finley, since Judge Morrison issued the bond and it's from her courtroom, if you want to get a modification, you can go back to her, okay?
Understood. Thank you, Judge.
All right. Good luck to you, sir.
Your Honor, next we have position number 18, Mr. Brandon James.
Good morning, Mr. James. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes.
Thank you. Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you. You can put your hand down. Is this negotiated, Mr. Finley?
Judge, this is going to be a non-negotiated with the probation at issue. Balance probated, balance suspended.
Okay.
He's been in jail for, just to make sense, for, I believe it's about 330 days now for this charge.
How long has he been in custody on this? In this
Pulling up the
case?
exact number right now. I believe it was around 330 or so.
I can look it up, Your Honor.
I got it right here. It's yeah, so he's been 329 days now.
Just on these charges? Or was he in for
For these
something?
charges, yeah, it's under the booking number for this case, it has 329 days if
Okay,
Ms.
all right,
Tortorella sees anything different.
all right. Ms. Tortorella?
Yes, Your Honor. So let me go back to the page I was looking at before. Okay, for battery and family violence, we're asking for 12 months of probation, family violence intervention program, no contact with the victims, and their names are Tamika Terry. That's for the record, it's T-A-M as in Mary, I-K-A. Terry is T-E-R-R-Y, and the juvenile victim, E-E. To stay away from the incident location at 1566 Avon Street. That's A-V as in Victor, O-N as in Nancy, Avenue Southwest in Atlanta. And 40 hours of community service. We are giving him time served for the battery and for the cruelty to children in the 3rd degree. And similar convictions. He was convicted of battery in Lowndes County, a state court on May 2nd, 2019. The facts of the case: on July 21st, 2021, Officer Jay Whitehead of the Atlanta Police Department was dispatched to a dispute call at 1566 Avon Street, Avenue Southwest in Atlanta. Upon arrival, the officer spoke to the victim, Tamika Terry, who said her live-in boyfriend, defendant Brandon James, had just assaulted her. Ms. Terry said that she and the defendant were involved in a verbal dispute that turned physical when he struck her several times in the face. The officer observed that Ms. Terry had a bloody nose and bruises on her arm and hand. Juvenile E.E., daughter of Ms. Terry, attempted to separate the two parties, at which point the defendant struck the juvenile in the nose. The officer did not observe injuries on the juvenile. Witness Tony Wyatt advised officer he witnessed the whole incident and called 911 immediately. And all these events did occur in Fulton County, Georgia. Nothing further.
Mr. Finley?
Yes, Judge. As previously stated, Mr. James has been in jail for 329 days now. So that would leave probation. I guess that would be, what, about 36 more days or so. Mr. James does not want contact. So that is not an issue. He hasn't had contact, obviously, does not want any part in contact. And he's had 329 days now to sit within his cell and think about this case. I think he's paid his dues, and I would think this young man should get on with the rest of his life. And I think that should begin once he steps out of the jail. So that's why, Judge, am asking just for the balance to be suspended once he gets out, Judge.
Does he have any reason to go back to that Avon Street address?
I don't believe so. Is that correct, Mr. James? You don't need to go back there, right?
No, sir.
Okay. All right. Anything further?
Nothing further, Judge.
From the state, if he only has several days left, we would at least, because family violence intervention is 6 months, so maybe switch that to an anger management, Your Honor. We object to a no-low plea. Nothing further.
Was he asking for a no-low plea?
Oh, yeah, I apologize, Judge. I did have that in the announcements, but I didn't say that. Yeah, he was asking for a no-low, Judge. And yeah, and once again, Judge, I just want to emphasize he's sat within the 4 walls of his cell for 329 days now. And I think that amount of time is plenty sufficient. Balance to be suspended.
Good morning, Your Honor. Respectfully, I just wanted to clarify regarding the jail time. And Ms. Tortorella, correct me if I'm wrong. I'm looking at the jail screen. It appears, Judge, that this case started out originally as a felony. It has a CP, a complaint room number. So that would indicate to the state that the case initially started out as a felony case and then was transferred to the district attorney's office. Ms. Tortorella, can you affirm that?
That's correct, DASG McCutcheon.
All right. I just wanted to put that on the record, Your Honor. That explains the length of time that the defendant has, in fact, been in custody. The case was transferred to our office from the district attorney's office for misdemeanor prosecution.
All right. Thank you, Ms. McCutcheon. Good morning.
Good morning, Judge.
All right, anything further, counsel?
Nothing further, thank you.
All right. Mr. James, it's my understanding in a case 22 CR 0035006H, Mr. Finland, I'm sorry, I'm not going to allow him to plead no low. So I will consider a guilty plea and the rest of your argument.
Okay, understood. Does that sound okay, Mr. James? So wouldn't be now, okay.
Again, Mr. James, it's my understanding in case 22 CR 0035006H, you wish to plead guilty to battery, family violence, battery and cruelty to children in the 3rd degree. Is that correct?
Yes.
Are you under the influence of any drugs or alcohol at the present time?
No, sir.
You've been represented by counsel. Are you satisfied with your counsel's representation?
Yes.
You understand that you have a right to a trial by jury on these charges and that by pleading guilty to them, you're giving up your right to a trial by jury?
Yes.
Has anyone forced or coerced you to plead guilty?
No, sir.
I'll accept your guilty plea, Mr. James. The sentence for each charge is going to be 12 months to serve, 329 days, credit for time served, 329 days, balance suspended, stay away from Tamika Terry, and no further contact with Ms. Terry, and stay away from the 1566 Avon Street address. All right, good luck to you, sir.
All right, thank you.
All right, next we have position number 21, Mr. Manning.
And Ms. Harrison, I'm going to need the history on this also, please.
Yes, Judge.
Good morning, Mr. Manning. I'm Judge Eric Morrow. This is the state all-purpose calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, Lord.
Thank you. Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, Lord.
Okay, you can put your hand down. Thank you, Mr. Manning. What's the history, Ms. Harrison?
25 cycles, 1 arrest in Florida, last arrest, April of this year for criminal trespass, and a misdemeanor CWAC charge in DeKalb County. That appears to be an open case, 22S002403. Record also indicates an additional open case for obstruction of law enforcement officers, threats of violence, 22 CP 206588 in DeKalb, and two counts of theft by shoplifting and willful obstruction, 20S 259658 out of DeKalb. A 2018 battery conviction, a 2017 battery family violence, and a 2019 simple battery in Clayton. 4 violations within the past of probation within the past 10 years. Nothing further to add.
Thank you. Ms. Mitchell?
Yes, Your Honor, the state is recommending 12 months to serve, 180 days, credit for time served 36 days, balance probated, SDET, a stay away from all Georgia State University properties. Your Honor, I won't sound on the facts or the nature of these allegations, but they are very concerning, especially for the safety of the students for Georgia State University. The defendant is a convicted felon with a violent history of crimes against women. We heard the open cases from pretrial, including the one in April that is similar in nature to what's before us today, and then the open felony obstruction and criminal trespass in February. The defendant also has a battery domestic violence conviction in 2018 from Florida. He also has a simple battery conviction in 2019 in Georgia, a violation of family violence order in 2019, a battery, family violence, and disorderly conduct conviction in 2017, and 2 simple battery convictions, one in 2017 and 2011. So based on his history, we will object to any NOLO and jail time reduction in this case. Nothing further, Your Honor.
Thank you. Mr. Ford?
Thank you, Your Honor. My client's 32 years old, Your Honor, and he has no reason, and I've talked to him, to go back to the Georgia State University property. So a stay away, I think, it would be appropriate to protect any safety if there's a concern. These are not violent crimes. We're talking about one misdemeanor case that's not a violent crime, and another, the one is loitering and prowl. Mr. Manning has no concerns staying away from the campus. He's trying to get employment. He was in the process of getting employed. He has now since lost that opportunity. I believe 180 days will do nothing but prevent him from dealing with some of the other issues that he has that I think are a little more pressing than this particular case itself. He has 2 children, a boy 6 and a girl 8, that he wants to get out and make sure he's employed so he can help support them. He is married. He has his wife, Naomi Manning. And so, like I said, at this point, Your Honor, my client is very interested in dealing with the issues that are more pressing than this one, to get this one behind him. I don't believe 180 days incarcerated will help him move his life forward. We're looking for it to be reduced by half to 90 days, Your Honor. That would give him another 9 days that he'd have to serve in Fulton County Jail, so he then can go out, help support his family, and deal with the other pressing issues that he does have. So, Your Honor, we're asking for a NOLO plea at this point, and also asking for his jail time to be reduced from 180 days to serve to 90 days to serve.
Anything further, Ms. Mitchell?
And
Oh, Your Honor.
Your Honor, I would like to, when placed on probation, if his probation fees could be waived, and the condition that has been placed on here, once that's completed, that he goes to either non-reporting or terminate.
Okay. I'm not going to allow him to plead NOLO. Mr. Ford, I will consider the your other arguments regarding jail time in this matter.
All right. Mr. Manning, do you understand that you will not be able to use a NOLO? I know you had asked for that, but you'd have to plead guilty, but the judge is willing to consider a possible reduction.
Yes, Lord.
All right. So you're okay with that?
Yes, I am satisfied.
All right. We're ready to proceed.
Thank you. Mr. Manning, it's my understanding in case 22 CR 002855G, you wish to plead guilty to one misdemeanor offense and loitering or prowling. Is that correct?
Yes, Lord.
Are you under the influence of any drugs or alcohol at the present time?
I am not.
You've been represented by counsel. Are you satisfied with your counsel's representation?
I am.
You understand that you have a right to a trial by jury on these charges, and that by pleading guilty to them, you're giving up your right to a trial by jury?
Yes, Lord.
Has anyone forced or coerced you to plead guilty?
I have not.
I'll accept your guilty plea, Mr. Manning. The sentence will be 12 months to serve 90 days, credit for time served 36 days, balance probated, and SDET, stay away from all Georgia State properties. I'm going to waive the probation fees while you're on probation to help you get and stay on your feet, but I'm going to require that you be on probation reporting the entire time. Good luck to you, Mr. Manning.
Bless you, Your Honor.
All right, next we got number 30, Mr. Stewart.
Good morning, Mr. Stewart. I'm Judge Eric Morrow. This is the state all-purpose calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Can't hear you. Can you repeat it?
Yes, we're doing this by video today. Do you agree to have your case heard by video?
Oh, yes.
Okay, can you raise your right hand for me, Mr. Stewart? Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, thank you. You can put your hand down. Ms. Mitchell?
Yes, Your Honor, the state's recommendation is 12 months to serve, 28 days, credit for time served 14 days, balance probated, $500 fine, a risk reduction course, an ADET, a VIP, 40 hours community service, and no alcohol, drugs, and weapons. Your Honor, I believe the only thing that's non-negotiated here or at dispute here is it being NOLO, and the state's going to object to that based on the charges before the defendant. Nothing further.
Mr. Ford?
That's correct, Your Honor. The only issue here is NOLO. My client, this will give my client an opportunity to get his driving privileges back sooner. He's self-employed. He does flooring, Your Honor, so that he needs to be mobile. He has to be mobile to do that. Unfortunate set of circumstances. He does have 3 children that with his business, he does help to financially support. At this time, he's 29 years old. He's at the stage in his life where he's turning the corner, Your Honor, and he's got his own business. He went back and received his GED as well, Your Honor. So here's a person who's trying to get on track, better himself. And so at this point, Your Honor, trying to protect his driving privileges and his record at this time. So we're asking for a NOLO. I don't believe he's used one in the last 5 years. And this is a driving offense, Your Honor.
Okay, and that's also a 2018 offense. I will allow him to use the NOLO, Mr. Ford.
Thank you, Your Honor.
Anything further?
Nothing, Your Honor.
No,
All
Your
right.
Honor.
Mr. Stewart, it's my understanding that you wish to plead NOLO to driving under the influence of alcohol, less safe, reckless driving, possession of open alcohol container, and speeding. Is that correct?
Correct.
Were you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with your counsel's representation?
Yes, I am.
You understand that you have a right to a trial by jury on these charges, and that by pleading NOLO to them, you're giving up your right to a trial by jury?
Yes, sir.
Has anyone forced or coerced you to plead NOLO?
No, sir.
I will accept your NOLO plea, Mr. Stewart, with the sentence being 12 months to serve 28 days, credit for time served 14 days, balance probated, a $500 fine, the risk reduction course, alcohol, drug evaluation and treatment if necessary, VIP, 40 hours of community service, and no alcohol, drugs, or weapons while out on probation. I'm going to waive the probation fees for you while you're on probation to help you get and stay on your feet. And when you complete the terms, it'll go to a non-reporting status, okay?
Okay.
All right, good luck to you, sir.
All right, next we got number 5, Mr. Brewer.
Have you spoken with him, Mr. Finley?
I have, Judge, and this will just be arraigned, please.
Okay. Good morning, Mr. Brewer. I'm Judge Eric Morrow. This is the state all-purpose calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video? Mr. Brewer, did you hear me?
What you say?
We're doing this by video. Do you agree to have your case heard by video?
Yes, ma'am. Yes, sir.
Okay, can you raise your right hand for me? The other one. Do you swear from the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can put your hand down. Thank you, Mr. Brewer. You've been charged in case 22 CR 002221A with simple battery family violence. This charge carries with it a maximum penalty of 12 months in jail and or $1,000 fine. Do you waive formal reading of the accusation, Mr.
Thank you,
Finley?
Judge.
How do you plead to this charge, Mr. Brewer? Guilty or not guilty?
Not guilty.
Okay, we will record your not guilty plea. Your case will be returned to the division judge and you will get notification of your next hearing date, okay? Good luck to you, sir. Who do we have next?
John, we're going to courtroom 2, position number 22, Mr. McKeever.
Okay. Good morning, Mr. McKeever. I'm Judge Eric Morrow. This is the state all-purpose calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, sir.
Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right, you can put your hand down, Mr. McKeever. Who's presenting for the state?
That will be me, Your Honor.
Okay, and this is your case, Mr. Finley?
I apologize, Your Honor. That's my case, Your Honor.
Oh, I'm sorry, Mr. Ford. All right, I just wanted to make sure that we were all present. Go ahead, Ms. Mitchell.
Your Honor, the state's recommendation is 12 months to serve 32 days, credit for time served 16 days, balance probated, a theft prevention course, and 60 hours community service, and no alcohol, drugs, and weapons. And is this one? This is position 22. This is also the only, I believe the only thing at issue here is whether it's no-low, and the state's going to object to that due to the defendant's history. The defendant has 55 cycles with a history of theft. If Your Honor would like to hear from pretrial, but it's an extensive history of theft, and the charge before us today is theft.
Okay.
Your Honor, and I apologize, I must have, but we were looking at the reduction in the community service as well.
Okay.
Okay.
Given his history, I'm not going to allow him to plead no-low, and the 60 hours seems to be reasonable to me. Anything further, Mr. Ford?
Nothing further. Did you understand that, Mr. McKeever?
Yeah.
There will be no reduction in your community service, and the judge is not going to allow you to plead no law. Are you prepared to proceed?
Yes.
Okay. Mr. McKeever, it's my understanding that in case 22 CR 003417D, you wish to plead guilty to theft by receiving stolen property. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with his representation?
Yes, sir.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
I'll accept your plea, Mr. McKeever. The sentence is going to be 12 months to serve 32 days, credit for time served 16 days, balance probated, a theft prevention course, 60 hours of community service, and no alcohol, drugs, or weapons while on probation. I'm going to waive the probation fees for you while you're on probation. And as soon as you complete the terms, it'll go, the probation will terminate, okay?
Sir.
All right, good luck to you, sir.
Next, we have position number 24, Mr. Oliphant, Michael Oliphant.
Good morning, Mr. Oliphant. I'm Judge Eric Morrow. This is the state all-purpose calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, sir. Good morning, sir.
Good morning. Can you raise your right hand for me? Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can put your hand down, Mr. Oliphant. Thank you. Ms. Mitchell?
Yes, Your Honor, our recommendation is time served, 15 days, balance suspended, and to stay away from ARDA. The only thing at issue here again is, I believe, no-low, and we're gonna object to that based on his history. He has 33 cycles with an extensive history of theft and criminal trespass. So based on that, we are objecting to the no-low.
Okay.
Thank you.
Thank you. Mr. Ford?
Thank you, Your Honor. Your Honor, we're asking for a no law in this matter. Even though he does have the 33 cycles, at this point, we're asking to protect his record going forward. And so we're asking for a no law. He was working at the Waffle House, Your Honor. He's working at the Waffle House. All of his children are adults, so he's able to raise his children. He has a sister that's really involved in his life as well. So at this point, Your Honor, we just want to protect this record. So at this point, we're asking for a no vote.
Ms. Harrison, does he have any criminal trespass convictions in his history?
One moment, Judge. I'm showing just thefts. I'm not seeing any trespass violations. I'm sorry, convictions.
All right. Thank you, Ms. Harrison. I'll allow him to plead no low, Mr. Ford. Anything further?
Nothing further, Your Honor.
Does he have a stay away suspension already in place from Martin, Ms. Mitchell? Do you know?
This was position 24, right?
That's correct.
Not that I'm aware of, Your Honor.
So I'm just gonna have him abide by any active stayaways from Marta, okay? All right, so Mr. Oliphant, it's my understanding that you wish to plead no low to criminal trespass and fear evasion in case 22 CR 003441Y. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol at the present time?
No, sir.
You've been represented by counsel. Are you satisfied with your counsel's representation?
Yes, sir.
You understand that you have a right to a trial by jury on these charges and that by pleading guilty to them, you're giving up your right to a trial by jury?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
I'll accept your, to plead no low, excuse me. I'll accept your no low plea, Mr. Oliphant. The sentence is going to be 12 months to serve 15 days, credit for time served 15 days, balance suspended, and to abide by any active stayaways from MARTA. Good luck to you, sir.
Your Honor.
Yes, ma'am.
I'm not sure if just for the record, from looking at his history, I do see criminal trespass convictions. I just wanted to put that on the record.
Okay, thank you, Ms. Mitchell. Yeah, it's noted. All right, who do we have next?
Position number 13, Mr. Christopher Day.
And Judge, I am asking for us to be able to go into a breakout room with you, possible.
Okay, that's fine. And this is going to be
bond hearing.
Okay, so who needs to go into the breakout room? Mr. Finley, Ms. Tortorella, Ms. McCutcheon? Anyone else? Okay.
I think that's good.
Okay.
The court reporter. Sorry, Your Honor.
I take it that we're going into a breakout room because you don't want this on the record, Mr. Finley, is that right?
Yes, involved, yeah.
Okay, all right, so Ms. Champion, if you can put us into a breakout room, please. Okay, so Mr. Day's bond will remain the same at this time. Who do we have next?
Your Honor, we're gonna go to medical.
Okay, and who do we have in medical?
All right, we have position 28.
Good morning, Mr. Short. I'm Judge Eric Morrow. This is the state all-purpose calendar that we are conducting by video to help prevent the spread of the virus. Did you have your case heard by video? Got a yes? Can you hear me, Mr. Short?
What did you say, sir?
I said we're doing this by video. Do you agree to have your case heard by video?
Yes, sir.
Okay, can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can put your hand down, Mr. Short. Ms. Mitchell?
Yes, Your Honor, the state's recommendation is 12 months to serve, 156 days, credit for time served, 78 days, balance probated, a $300 fine, a risk reduction course, 40 hours community service, ADET, and a VIP. And no alcohol, drugs, and weapons. I believe the only thing at issue here again is the NOLO. Based on the defendant's history, he does have 17 cycles. He has position 28. Yes, he has a DUI arrest in 2016 and 2014 where the disposition is not listed. So based on that, we are recommending or we're objecting to the NOLO. Thank you.
Okay, Ms. Harrison, do we have his complete history?
I apologize, Your Honor. I don't have a history on this defendant.
Okay. Mr.
Your
Ford?
Honor, yeah, Your Honor, and Mr. Short it has positions 28 and 29.
Okay.
ASG Mitchell is correct. The only issue we have with on 28 is the NOLO, and we asked for that because of the driving offense, Your Honor. He has not used the NOLO in the last 5 years, and we'd like to have that driving offense be a NOLO. The second case, if you'd like to take them both at the same time, is case 29. The only issue we do have a NOLO issue there, but Your Honor, we'd like to use a NOLO for position 28. The only other issue is the anger management, Your Honor. It's for 12 weeks. Due to my client's, he is an independent contractor. That position may be he might have lost his opportunity with the contract he does have, Your Honor. So we'd ask that the 12 weeks of anger management be reduced to 4 weeks, so he can go out and try to get the job back. We ask that his time on probation fees be waived, and once he completes any conditions, that he go to his probation be terminated on both 28 and 29.
Okay. Thank you. Can you all hear me?
Yes.
Yes.
Okay. My camera is not able to activate, so I'm going to have to leave and come back in so that I can rectify this my video. So I'll be right back.
Okay.
Okay, that's better. Ms. Mitchell,
Yes, Your Honor.
can you tell me about position 29, the battery substantial physical harm charge, please?
Yes, in that case, the defendant battered Mr. Andre, spelled Andre, Callaway, common spelling, by punching, kicking, and hitting him in the face with a belt. Mr. Calloway suffered a busted lip and swollen eye. Mr. Calloway had disability, so he wasn't able to provide a statement to the officer, but a witness, I believe his caretaker mother, was able to confirm that the defendant did in fact batter Mr. Calloway. The defendant admitted that he was fighting everybody that was at the bus stop at the time because they were trying to jump him. And then he also admitted to hitting Mr. Calloway. So our recommendation for that is going to be 12 months to serve, 156 days, credit for time served, 78 days, balance probated, a 12-week anger management course, no further contact with Andre Calloway, a stay away from the bus stop on 5084 Old National Highway and Godby Road, College Park, Georgia. No alcohol, drugs, and weapons. Your Honor, the defendant does have a violent history. He has a terroristic threats, an acts and aggravated assault case that appears to be open in 2021. He had a battery arrest 2019, a battery that was amended to a disorderly conduct conviction in 2016, a battery arrest in 2019. Well, I believe I said that. Terroristic threats in 2018, and a SIPA battery conviction in 2011. So based on his history, we're going to object to the NOLO. And from his history, it appears he does need the AM courses. Thank you, Your Honor.
Okay, so Mr. Ford, in the position 28, I will allow him to plead NOLO. It's a 2016 case. For the position 29, if he wants to plead guilty to that charge, I'm going to accept the state's recommendation for the sentence in that matter.
Mr. Short, did you understand that? Mr. Short?
Yes, sir.
Did you understand what the judges has decided? You will be able to use the NOLO for the case 28, position 28, which is the DUI case. But he's not allowing you to use a NOLO for the case with the battery, so substantial physical harm case. So you'd have to plead guilty to that. Are you prepared to proceed?
Yes.
Okay. All right.
Very good. Mr. Short, it's my understanding in case 17 CR 005281Y, you wish to plead NOLO to following too closely: reckless driving, DUI under the influence of alcohol, less safe. And in case 19 CR 009342Y, you wish to plead guilty to battery, substantial physical harm. Is that correct?
Yes.
Are you under the influence of any drugs or alcohol this morning?
No.
You've been represented by counsel. Are you satisfied with your counsel's representation?
Yes, sir.
You understand that you have a right to a trial by jury on these charges, and that by pleading NOLO and guilty to them, you're giving up your right to a trial by jury?
Yes, sir.
Has anyone forced or coerced you to plead NOLO and guilty to these charges?
No, sir.
I'll accept the pleas. In case 17 CR 005281Y, the sentence will be 12 months to serve, 156 days, credit for time served, 78 days, balance probated, $300 fine, risk reduction, 40 hours of community service, ADET and VIP, and no alcohol, drugs, or weapons while on probation. In case 19 CR 009342Y, the sentence will be 12 months to serve, 156 days, credit for time served, 78 days, balance probated, 12-week anger management course, no further contact with Mr. Calloway, stay away from the bus stop at 5084 Old National Highway, Godby Road, and no drugs, alcohol, or weapons while on probation. I'm going to waive your probation fees while you're on probation to help you get and stay on your feet. And when you finish the terms of the probation, it'll go to a non-reporting status, okay?
Thank you, Your Honor.
Good luck to you, Mr. Short.
Thank you, sir.
All right, next case is 26.
Let's see, Mr. Rutledge.
Yes, sir.
Good morning. I'm Judge Eric Morrow. This is the state all-purpose calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, sir.
Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
I swear.
Okay, you can put your hand down. Thank you, Mr. Rutledge. Ms. Mitchell?
Yes, Your Honor, in this case, the state's recommending time served, 15 days, bail unsuspended, and a stay away from MARTA. Again, this is a NOLO issue, and the state's gonna object to that. The defendant does have 41 cycles, and he has criminal trespass convictions in 2020, 2019, and in 2018. He used his NOLO for criminal trespass
What year was that, Ms. Mitchell?
in 2018.
Mr. Ford, anything further?
No, Your Honor, we're asking for the NOLO. We know it's under the judge's discretion. This is a criminal trespass and fair evasion cases, Your Honor. We're asking due to Mr. Rutledge, he has a construction job. He would like to, like I said, protect his record as much as possible. He is a lifetime resident. I think he would be a good candidate for going ahead and use his NOLO at this time.
Okay, given his history, I'm not gonna accept a NOLO, but I will, if he wants to plead guilty.
I plead guilty.
All right.
Mr. Rutledge, it's my understanding that you wish to plead guilty in case 22 CR 0034447J to criminal trespass and fair evasion. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with his representation?
Yes, sir.
You understand that you have a right to a trial by jury on these charges and that by pleading guilty to them, you're giving up your right to a trial by jury?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
I'll accept the plea as negotiated. Mr. Rutledge, and you are to abide by any active MARTA suspensions, okay?
Okay, thank you.
All right, good luck to you, sir.
Good luck to you too, sir.
We go back to courtroom too.
Okay, who do we have?
Your Honor, we got the private attorney, position number 6, I was trying to do earlier, Mr. Carmichael.
Okay.
Good afternoon, Your Honor. Or good
Good
morning.
afternoon. Good morning. How are you today?
I'm doing well. I apologize. I had 3 cases all set up for 9 a.m. this morning.
No worries at all. What are we doing with Mr. Carmichael today?
I just got retained yesterday on this matter, and I need to pre-try it with the state. He has a probation hold right now. He would not be released either way. So I guess I'm asking for a little bit more time to work this out.
That's fine. Would you like to place it on next week's Tuesday SAP calendar? Is that enough time, or do you? Or we can set it out 2 weeks if you want, whatever you prefer.
And I do have a conflict at 9 a.m. in Cobb, but that shouldn't take more than an hour. So because I don't want to belabor it too long. Is next Tuesday okay?
Yes, that's
the only thing I have.
Yes.
Okay, so
yes, I wouldn't mind be placed on the next Tuesday's calendar with that caveat that I will be there as soon as I finish in Cobb.
Okay, that's fine. So we will reset this until June 21st, I think. That's the date.
Hey, Your Honor, can I speak really quick?
No, you have, Mr. Carmichael, you have the right to remain silent. Anything you say can be used against you. Your attorney will be getting in touch with you to discuss the case, and I'll see you back here next Tuesday. Okay?
It wasn't about my case exactly.
Well, if still, I would, I would imagine.
Mr. Carmichael, I'll call you.
Okay. Would advise you to remain silent at the present time. Okay?
Thank you.
All right, so we'll see him back next week.
Thank you, Your Honor.
You're welcome. Do you have any other cases on the calendar today?
I do not. May I be excused?
Yes, have a good rest of your day. Thank you.
You too. Bye-bye.
All right, next we got number 12, Mr. Cummings on 4 South.
Okay. Good morning, Mr. Cummings. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video? Yes? Okay, you're gonna have to speak up a bit for me, Mr. Cummings. We have a court reporter taking down everything and it's a little hard to hear from time to time, okay?
Yes, sir.
Okay. Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can put your hand down. Thank you, sir. Ms. Tortorella?
Yes, Your Honor. The defendant's being charged with, as you know, the charge on the calendar, Your Honor. We would not like to state it on record because of the nature of the charge. The offer is time served, balance suspended, and to stay away from the incident location, which is the First Baptist Church of East Point at 2813 East Point Street, East Point, Georgia. Nothing further.
How many days has he, is he getting credit for?
I have to look that up, Your Honor.
Okay, we just have to put that on the paperwork, so.
Yes, Your Honor. Give me a minute.
Okay, Mr. Finley?
Yes, Judge. That is our understanding of the offer, of which Mr. Cummings does agree. And additionally, we stipulate the factual basis of venue and ID, Judge.
Okay, Mr. Cummings, it's my understanding that you wish to plead guilty to one misdemeanor charge. Is that correct? Are you under the influence of any drugs or alcohol at the present time? You are? My question was, are you under the influence of any drugs or alcohol?
No.
Okay, you've been represented by counsel. Are you satisfied with his representation?
Yeah.
You understand you have a right to a trial by jury on this charge and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yeah.
Has anybody forced you to plead guilty?
No.
Okay, I'll accept your guilty plea as negotiated, Mr. Cummings. Do we know how long it's been?
Yeah, it was 9 days, Judge.
Okay. 12 months to serve 9 days, credit for time served 9 days, balance suspended. Good luck to you, Mr. Cummings. And stay away. Don't go back to that Baptist church, the First Baptist Church, okay? All right, good luck to you, sir.
All right, next we got 1 and 2, Mr. Avery.
Have you spoken with Mr. Avery? Mr.
I have
Finley?
not, Judge. Yeah, I'm gonna need to get in a break
Okay.
room with him if I can.
Okay, so where's Mr. Avery? Is he in 4 South?
Yes, sir.
Okay, so let's put Mr. Finley in 4 South into a breakout room, and maybe we can go back to courtroom 2. I don't know if there's anyone in courtroom 2. That is Mr. Ford's.
Actually,
case.
Your Honor, both the last 2 clients I have there is Mr. Forge.
Okay, great. All right, so who do we have?
I have position number 35, Mr. Truelove.
Okay. Good morning, Mr. Truelove. I'm Judge Eric Morrow. This is the state all-purpose calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, sir. Yes, sir.
Thank you. Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can put your hand down, Mr. Truelove. Ms. Mitchell?
Yes. Your Honor, the state's recommendation is going to be 12 months to serve, 30 days, credit for time served, 15 days, balance probated. No further contact with Lewis, spelled L-U-I-S, Nunez, spelled N-U-N-E-Z. A stay away from the Holiday Inn located on 909 Holcomb Bridge Road, Roswell, Georgia. An 8-week anger management course, 40 hours community service, and no alcohol, drugs, and weapons. Your Honor, the defendant criminally trespassed at the Holiday Inn and pushed past the night manager who was working at the time, which was Mr. Luis Nunez. They met at the locked entrance. Mr. Nunez unlocked the door to see if the defendant needed assistance or if he had a question or was a resident. That's when he unlocked it, the defendant pushed past him and ran to the ice machine room and sat down until the manager located him. He stayed in that ice machine room for the purpose of hiding from Mr. Nunez. Once Mr. Nunez found him, the defendant jumped up and attempted to keep the door to the ice machine room shut. That's when he battered Mr. Nunez by punching him in the chest in an attempt to keep that door shut. The defendant then ran out the back door. Your Honor, the state is going to object to the NOLO. The defendant has used a NOLO for criminal trespass and giving false info in 2021. He also appears to have an open criminal trespass case. He also has a disorderly conduct case in 2021 where the disposition is not listed. Criminal trespass. The defendant has 2 counts of criminal trespass convictions in 2020, a battery conviction in 2010. And so based on that, we are gonna object to the reduction of anger management, and we believe he should have no issues doing the community service as well. So thank you.
Thank you, Ms. Mitchell. Mr. Ford?
Thank you, Your Honor. With that, disagree with the ASG at this point. He will have some issues with the conditions. My client is not working at this time, Your Honor. He has no transportation. He does have a stable address in Duluth, Georgia. We'd ask that the court use their discretion on the NOLO, but we'd ask that the 40 hours of community service be reduced by half. Also, the anger management be reduced by 4 weeks. Even with those reductions, Your Honor, I think it's going to be somewhat of a chore for my client to complete those conditions. He has no problem staying away from the holiday, the incident location. He does not even know who Mr. Luis Nunez is. So at this point, Your Honor, we're just asking for the court to use their discretion on the NOLO and at least reduce the anger management by half, which is 4 weeks, and also the 20 hours of community service, because I just think that that might be a situation where my client will fail if he doesn't have some relief there. Also, while he's on probation, Your Honor, we ask that his fees be waived. And once he does complete those conditions, Your Honor, that his probation be terminated.
Given the facts of this, of the situation, Mr. Ford, is this, in your belief, an anger issue or is this a mental health issue?
Well, Your Honor, and I'm going to say it's neither, Your Honor. It's a case of my client making a bad choice, which I don't believe is a mental health issue. I don't believe it's an anger issue. People do make bad choices, and their decisions put them in a position where they find themselves in court like we are today. But I talk with Mr. Truelove, and I don't see an anger issue or a mental health issue with him. I just think it was just a bad choice, bad decision on his part.
I'm just trying to wrap my head around this. I apologize, Mr. Ford, but a bad decision to push past a guard at the front of whoever he was, and and hide in an ice. That just doesn't make any sense to me. So something else is going on. I mean, something has to be going on. And if it.
Yeah, I don't want to get too in depth with my discussion because of the client attorney privilege situation, Your Honor, but it was, he had some reasons, but I do not want to put those on the record.
Okay. Well, in that case, then, given what I've been told about his history, I will not allow him to plead to use a NOLO, and I'll accept the state's recommendation regarding the sentence.
All right, Mr. Truelove,
Yes, sir.
did you hear the judge's decision is that you will not be able to use a NOLO, and you would have to complete the 8 weeks of anger management and the 40 hours of community service. Are you prepared to do that?
Yes, sir. Now, are they talking about a release today to do that, or are they talking about?
No, yeah, you will be released today if there's nothing else holding you in, and I checked it. I don't believe there is. So yes, you will be released today within 24 hours.
Yes, sir. All right, thank you. Yes, I agree to everything. I agree to everything, Your Honor.
Okay, all right. So, Mr. Truelove, it's my understanding that you wish to plead guilty in case 21 CR 006684A with simple battery and criminal trespass. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with his representation?
Definitely, yes, sir.
You understand that you have a right to a trial by jury on these charges, and that by pleading guilty to them, you're giving up your right to a trial by jury?
Yes, sir.
Has anybody forced or coerced you to plead guilty?
No, sir.
Okay, I'll accept your guilty plea, Mr. Truelove. The sentence will be 12 months to serve 30 days, credit for time served 15 days, balance probated. No further contact with Mr. Nunez. Stay away from the 909 Holcomb Bridge Road address, 8 weeks of anger management, 40 hours of community service. No drugs, alcohol, or weapons while on probation. I am going to waive the probation fees for you while you're on probation to help you get and stay on your feet. And when you complete the terms of the probation, it'll go to a non-reporting status, okay?
Yes, sir. All right.
All right. Good luck to you, Mr. Truelove.
Thank you.
All right, going back to 1 and 2. Mr. A.
Okay. Mr. Finley?
Yes, Judge.
What's the announcement?
Yes, this is going to be a negotiated plea, Judge.
Okay. Good morning, Mr. Avery. I'm Judge Eric Morrow. This is the state all-purpose calendar. We are conducting this calendar by video to help prevent the spread of the virus. Do you agree to have your case heard by video? Was that a yes?
Yes.
Okay. Can you raise your right hand for me, Mr. Avery? Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, you put your hand down. Thank you. Ms. Tortorella?
Yes, Your Honor. This will be a global offer. So for case number 22 CR 000687D, for the simple battery charge, it would be 12 months served 24 days, credit for time served 24 days, balance probated, a 12-week anger management, no contact with the victim, and his name is Ricardo Carmichael, traditional spelling. To stay away from the incident location at 490 Glen Street, Southwest in Atlanta. For the second charge, theft by taking, 12 months, served 24 days, credit for time served 24 days, balance probated. For the third count of, which is theft by taking, 12 months, served 24 days, credit for time served 24 days, balance probated, and $400 in restitution. And all charges would run concurrent on that case. For 22 CR 22 CR 002565D. In this case, Your Honor, will run consecutive to 22 CR 000687D. For the battery count, it's 12 months served 2 days, credit for time served 2 days, balance probated, 12-week anger management, and 40 hours of community service, and no contact with the victim. And her name is Taliba Parker. It's spelled T as in Tom, AHLIBAH, Parker, traditional spelling, and to stay away from 125 University Avenue in Atlanta. Nothing further.
All right, so let me make sure I have this right. because my calendar it just has a theft by taking at the top, so I have 22 CR 0000687D. Is that theft by taking?
Yeah, and last week, Your Honor, I added the simple battery and another count of theft by taking. So, and it was filed, and I noticed 2 days ago, it for some reason didn't go through and it was filed again. And I think case manager shows that it was filed, but for some reason doesn't reflect in the system. It's a little weird.
Okay, so I'm just trying to figure out what he's pleading to. So I've got that theft by taking, and then there's a simple battery that's associated with that same number.
Correct. Simple battery and 2 counts of theft by taking.
Okay, so 2 counts of theft by taking. And so for position 1, 2 theft by takings and 1 simple battery, is that right?
Correct.
Position 2, 1 simple battery.
Position 2 is 1 battery.
Okay, well, my calendar says simple battery, so 1, is it battery?
Yes.
Okay, and so there are 4 charges altogether?
Correct.
Okay. And is that your understanding, Mr. Finley?
Yes, Judge, that is my understanding, and I did just review that with Mr. Avery. Each of those, the simple battery, theft by taking, and the battery. I mean, he understood that this plea offer was for all of them.
Okay, all right. Mr. Finley, anything further?
Yes, Judge. That is our understanding of the offer, of which we do agree. Mr. Avery has agreed, obviously, to the time served and all these conditions. We would just ask that once he does complete those, if he could be non-reporting.
Any objection to non-reporting, Ms. Tortorella?
No objection, Your Honor.
Okay.
And I apologize, Judge. And also, if Mr. Avery, if the probation fees could be waived, as finances are a big issue in his life.
Okay. Mr. Avery, it's my understanding that you wish to plead guilty to 1 charge of simple battery, 2 charges of theft by taking, and 1 charge of battery. Is that correct?
Yes.
Are you under the influence of any drugs or alcohol this morning?
No.
You've been represented by counsel. Are you satisfied with your counsel's representation?
Yes.
You understand that you have a right to a trial by jury on these charges, and that by pleading guilty to them, you're giving up your right to a trial by jury?
Yes.
Has anyone forced or coerced you to plead guilty?
No.
I'll accept the guilty pleas as negotiated, Mr. Avery. I'm going to waive the fees, the probation fees for you while you're on probation to help you get and stay on your feet. And when you complete the terms of the probation, it'll go to a non-reporting status, okay? All right, good luck to you, Mr. Avery.
Next, we have position number 32, Mr. DeMarcus Stone.
Good morning, Mr. Stone. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Can you raise your right hand for me, Mr. Stone? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can put your hand down. Thank you, Mr. Stone. Ms. Mitchell?
Yes, Your Honor, the state's recommendation is going to be 12 months to serve, 26 days, credit for time served, 13 days, balance probated. No further contact with the victim, Leshania, spelled L-E-S-H-A-N-I-A, Lay, spelled L-E-I-G-H. A stay away from 2591 at the Ridge, apartment B420, Atlanta, Georgia. FFIP course, 40 hours community service, and no alcohol, drugs, and weapons. Your Honor, the defendant battered his girlfriend at the time, Ms. Lay, by striking her in the face, leaving her with an abrasion on the top part of her nose. I believe the issue here is NOLO and community service. We are going to object to the NOLO based on the nature of the nature of the charge is battery family violence, and the state takes our family violence cases very seriously. The defendant also has a simple battery family violence arrest in 2018. And he also has a burglary in 2017 that he pled first offender to. I mean, at this point, we don't see there being an issue with his community service either. So yes, we are objecting to those. Thank you.
Okay, Mr. Ford.
And I'll just let Ms. Mitchell know that we are also adding that there should be no further violent contact with the complaining witness as well. Your Honor, the state is asking for Mr. Stone. Well, Your Honor, can we have Ms. Lay speak before I make my presentation?
That's fine with me. Let's see, Ms. Lay, if you're on the line, I'll need for you to activate your camera and unmute yourself, ma'am.
Hello.
Good morning, Ms. Lay. Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can put your hand down. Thank you, ma'am. What would you like to tell the court?
Oh, I thought it had got thrown out, but y'all did. Y'all just said everything.
Okay. Did you want to say anything on Mr. Stone's behalf or not?
No, we haven't saw each other since, I guess, 2018 when it happened.
Okay, so there's no reason for Mr. Stone to be around you. Is that correct?
No, ma'am. No, sir.
Okay, and there's no reason for him to be at your apartment or your home, correct?
No, sir. I haven't saw him, talked to him until just now.
Okay, all right. So anything else you want to say to me, Ms. Slay?
No, sir.
Okay, thank you, ma'am. Mr. Ford?
Thank you, Your Honor. My client has not used his NOLO, I believe, Your Honor, in the last 5 years. And we're asking that his community service time be, that he does not receive community service time. He's already being asked, Your Honor, to do the FVIP, which is pretty standard for the family violence matters. But I would think because he has no job, he does have address. I do have a stable address, telephone number, and he does have support in the community with his mother. But I think doing the FVIP and having to do community service, I feel is a little excessive because you have to go to those classes, a 6-month program. And I believe that the 40 hours of community service could be waived at this time. So we're just asking that the community service, because we thought that was excessive, having them to do both community service 40 hours and having to do the FVIP as well.
All right,
Your
so
Honor, the state would like to add that we add on the community service instead of giving the defendant additional jail time. We thought that was a better option. So we're going to request that community service remain. Thank you.
all right. Let's see, Mr. Ford, I will allow him to use the NOLO, but all the other recommendations of the state with regard to sentence, I will also impose.
All right, Mr. Stone, did you understand that?
He's on mute, courtroom too.
Yes, sir.
Did you understand? You will be able to use the NOLO, but you will have to complete the 40 hours of community service along with completing the family violence intervention program. Do you understand that?
Yes, that's fine.
Okay. Your Honor, I would also ask, because you'll have to do both the 40 hours community service and the family intervention program, I would ask that his probation fees be waived. And once he does complete those conditions, that his probation be terminated.
Okay, I'll allow it to go to a non-reporting status, Mr. Ford.
All right.
Okay. Mr. Stone, it's my understanding that you wish to plead no to battery family violence. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol at the present time?
No, sir.
You've been represented by counsel. Are you satisfied with your counsel's representation?
Most definitely.
So that's a yes?
Yes, sir.
You understand that you have a right to a trial by jury on this charge, and that by pleading no to it, you're giving up your right to a trial by jury?
Yes, sir.
Has anyone forced or coerced you to plead no?
No, sir.
I'll accept the no plea. The sentence will be 12 months to serve 26 days, credit for time served 13 days, balance probated, no further contact with Ms. Lay, stay away from the 2591 Etheridge address, FVIP, 40 hours of community service, no drugs, alcohol, weapons while on probation. I am going to waive the probation fees for you while you're on probation, Mr. Stone, to help you get and stay on your feet. And when you complete the terms of the probation, it'll go to a non-reporting status, okay?
All right.
All right, good luck to you, Mrs. Stone.
All right.
Good afternoon, Your Honor. This is Officer Milton at the South Annex, sir.
It's still morning here, Officer Milton, but good afternoon to you.
I'm so sorry.
Milton, give me 1 second. I just need to give the judge a quick announcement,
Go ahead.
I forgot to tell you earlier, Your Honor. Mr. Tillman, he's in quarantine. That's position number 34.
34, okay. So,
and also position number 38, James Walker, he's actually released.
38, Mr. Walker was released. Okay, thank you.
All right, thank you. And may courtroom 2 be excused?
Yes, yes, Mr. Ford, go ahead.
Your Honor, with Mr. Tillman, I was able to see him as late, I think it was close to midnight when I saw Mr. Tillman. And he has a time served situation. I think him staying in jail, they said the quarantine, as long as he's masked up, he's able to come out and
he's able to come out in the zone, but I cannot bring him out of the zone, walk him down the hallway and then to courtroom 2. I can't do that.
Well, that's my objection, Your Honor. I believe Mr. Tillman has a time served situation. I just don't think that his quarantine should prevent him from accepting that offer at this time.
I understand, and I don't know what I can do in that regard, Mr. Ford, as the inmates are managed by the jail, and they have a protocol there. So I'm happy to reschedule him till possibly Thursday, or if anybody else has a solution, I'm happy to entertain it.
Well, Your Honor, respectfully, again, on behalf of the state, if that's the jail, the sheriff's office's protocol, then the state, as far as the Solicitor General's office, then we cannot oppose and we would not oppose what the sheriff's office has determined is most appropriate and is safe for both the defendant, inmate, and all of the other parties involved. So we'd request that the case be reset. Additionally, Mr. Ford, are you saying that your client has already communicated to you that he is accepting the plea offer?
What number are we on? 30? I think this is.
Was this your case we were just talking about, or was it Mr. Finley?
No, it was, yeah, he was accepting it. Only issue was that we were asking for no. That was it.
Well, Judge, it would seem to the state that the matter cannot come before the court if the defendant A is not present and B is unavailable because of a safety issue that the sheriff's office has determined to be appropriate. So we'd ask respectfully that the case be reset until Thursday.
Okay, and I don't know what else we can do, Mr. Ford, at this point in time. So it'll be reset until the 16th, which is Thursday.
I just wanted to offer that was my objection, Your Honor, because my client has a time served situation. So I'm representing my client.
I understand. I mean, I don't want anybody to stay in jail any longer than they have to either, Mr. Ford. So if there was a way that that we could safely get him here, then that would be fine with the court. But apparently there's not. So we'll have to go with the jail protocol. Okay. Anything further?
Is there any way to to have him go last, so where there'd be nobody in his area?
Well, I think the objection was that they
Mr.
have to
Ford,
walk
Mr.
in.
Ford, Mr. Ford, I'm going to try to do something. I'm going to try to go get a cell phone and see if you guys can do it behind doors. That's the best I can do.
Okay, well, that is a solution. So if you can get that done, that'll be wonderful. But if not, then let us know that too. But we
Thank you very
appreciate you
much
working with us.
for looking into that for my client. Thank you very much.
And Mr. Ford, and Your Honor, just on behalf of the state, that means even if it's done by phone, that the defendant would still have to be visible to the court.
Right,
I'll try to put the Zoom on. Ms. McCutcheon, I'll try to put the Zoom on so you'll be able to see it.
All right, thank you, sir.
Okay.
And just one additional thing, if I may, before courtroom 2 logs off. Position 4, Mr. Bogham, I think maybe you say it. I don't see it if he was released, so I'm not sure.
No, I didn't. I said position number 38.
That's Mr. Walker.
No, I know. I was saying, do you know Mr. Bogham, position 4, if he's coming? I mean, I guess.
That's another officer. He's taking care of that.
Okay.
Right. So, all right, anything further? Anything more for courtroom 2?
That's it, Your Honor. Let me just
All right.
Cell phone.
Okay, thank you. We appreciate it.
All right.
Okay, so we going to the South Annex?
Yes, Your Honor. As soon as you finish with Miss Coley, position 9, I will go and get the other young lady.
Okay, so this is position 9, Ms. Coley. Good morning, Ms. Coley. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, ma'am. Yes, sir.
Thank you. Can you raise your right hand for me, ma'am? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, you can put your hand down. Thank you, ma'am. Ms. Tortorella?
Yes, Your Honor.
And this is actually going to be a non-negotiated plea. I believe I put it wrong in the announcements with jail time at issue. Sorry, I didn't mean to cut you off. I just want to make sure I said that.
No, thank you. Okay, so this defendant is being charged with battery and the state's moving forward with said charge. The offer is 12 months, served 30 days, credit for time served 4 days, balance probated, 12-week anger management, no contact with the victim, and the victim's name is Antoine Russell. That's Antwan, and last name Russell with 1 L at the end. Your Honor, in this case on September 14th, 2021, Officer Scott of the Atlanta Police Department responded to 1094 La Rosa Terrace, Southwest, apartment H in Atlanta. For the record, La Rosa is spelled Larosa. And he responded in reference to a disturbance with possible injuries. Upon arrival, the officer spoke with the victim, Antoine Russell, who said his ex-girlfriend, defendant Tisa Cawley, had assaulted him by throwing hot cooking grease on him. Mr. Russell sustained first-degree burns on his arms and chest. The victim provided a description of the defendant, who was later found at a nearby Texaco gas station. The defendant advised officers that she did not throw the grease at Mr. Russell, but that Mr. Russell did choke her by putting his hands around her neck. The defendant did not have any visible injuries. The defendant was arrested and then complained to the officer that she was burned on her legs. The defendant was taken to Grady Detention and was to be in the burn unit for an undetermined amount of time. Therefore, the officer released her on copy of charges. All these events did occur in Fulton County, Georgia. And Your Honor, this defendant does not have any relevant convictions on her record. However, she has 6 cycles in Georgia, 20 cycles in Texas. Nothing further.
Mr. Finley?
Yes, Judge. As previously stated, this is a non-negotiated plea with jail time at issue. Ms. Cawley, as we heard, has no convictions on her record. She did really stress she really stressed that she wanted me to say she did have an FTA, which is why she was brought in. She wanted to make sure I say that she did go to court that day. She did not see her name on the docket, I guess on the screen, and she went to a clerk and asked, and that clerk looked at the docket too and said that she didn't believe she saw her name, so to not worry about it. So Ms. Colley really wanted to make sure I said that. She works full-time in landscaping, Judge. She's really eager to obviously get out. So the state is asking for 30 days, which after the 2-for-1 would mean she would have about 11 additional days. I'm just asking for her to get 15 days, which after the 2-for-1 would mean she would only have to serve another three or 4 days after the 2-for-1. And then once she completes the anger management class, that her probation could either be suspended or non-reporting, Judge.
All right, anything further, Ms. Tortorella?
Just that, Your Honor, the state's requesting the amount of jail time based on the allegations, the facts of the case. And that's it, Your Honor, nothing further.
Okay. Ms. Colley, it's my understanding that in case 21 CR 0073818, you wish to plead guilty to battery, is that correct?
Yes.
Are you under the influence of any drugs or alcohol at the present time?
No.
You've been represented by counsel. Are you satisfied with your counsel's representation?
Yes.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes, I understand.
Has anyone forced or coerced you to plead guilty?
No.
I will accept your guilty plea, Ms. Colley. The sentence is going to be 12 months to serve 15 days, credit for time served 4 days, balance probated, a 12-week anger management program. No further contact with Mr. Russell. Stay away from the Rosa Terrace address. No drugs, alcohol, weapons while on probation. I'm going to waive the probation fees for you while you're on probation to help you get and stay on your feet. And when you complete the terms of the probation, it'll go to a non-reporting status. Okay?
Okay.
All right. Good luck to you, ma'am.
Thank you.
Adriana, I'll be back with Miss Ula Ramirez. That's position 36 and 37.
Okay.
All right, thank you.
You're welcome. Can we go to medical?
Yeah, Judge, before we start, do we have a sign language interpreter?
Yeah, I did email yesterday and requested one. I didn't get a response. I'm not sure if I thought that was gonna happen, but I guess we're not.
Okay. Do we know whether we have a sign language interpreter requested for today? Ms. Champion?
I'm checking now, Your Honor. I don't show one on this in the Zoom, so I'm checking now to find out.
Okay. Is this the only person that we have at medical?
No, I still have two more. I have Mitchell, he position 23. I gotta go get him from 3 North. And do we know if we have a conflict attorney for Bradbury? Position 1.
I don't know. I don't see a conflict attorney on the line. I will.
She was here, Your Honor.
Oh, she was?
Miss McLeod was on for conflict attorney.
Okay. So if we
Your
can
Honor,
contact.
I am here, but I was here for Mr. Brady, for Eric Brady.
Okay, so we can't do whoever we have here because he needs an interpreter. Is there someone?
No, he don't. This is Clark position.
Oh, okay.
I was just trying to get some information so I can know what to do next after.
Oh, okay, okay. So can we go ahead and handle Mr. Clark? Is this your client, Mr. Finley?
Yes, Judge. Yeah, this is a negotiated plea. It's just straight time served.
Okay. Ms. Tortorella, you're presenting?
Yes, Your Honor. What position is Mr. Clark again? I apologize.
1717.
Position 7,
17.
17.
No, no.
No,
Clark is 7.
he's
Oh, he's
position 7. Yes.
Pull it up.
Yes.
Okay, got it. I'm sorry.
Okay, that's fine. Good morning, Mr. Clark. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Can you raise your right hand for me, Mr. Clark?
Yes, sir.
Thank you. Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
You can put your hand down, Mr. Clark. Ms. Tortorella?
Yes, Your Honor. In this case, the defendant is being charged with obstruction. The state is moving forward with said charge, and we are offering time served. The defendant has served so far for the obstruction. It looks like 17 days.
Mr. Finley?
Yes, Judge. That is our understanding of the offer of the time served, of which we do agree, and additionally stipulate the factual basis, venue, and ID.
All right, Mr. Clark, it's my understanding in case 22 CR 003384F, you wish to plead guilty to willful obstruction of a law enforcement officer. Is that correct?
Yes, sir.
Under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with your counsel's representation?
Yes, sir, I am.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes, sir, I do.
Is it forced or coerce you to plead guilty?
Yes, sir.
So nobody's forced you to plead guilty, have they?
No, sir. No,
Okay.
sir.
I'll accept your guilty plea as negotiated, Mr. Clark. Good luck to you, sir.
Thank you, sir. Thank you. Mr. Finn.
Yes, sir. No problem.
Okay. Ms. McLeod? Ms. McLeod, are you there?
I am. I'm here.
Position 1, Mr. Bradbury. Are you here for him today?
No, Your Honor, I'm here for Eric Brady.
Brady, okay. I've been informed that you were asked by Judge Law last week to represent Mr. Bradbury, and that's why he was placed on this calendar today. So if you need some time to speak with him.
Yes, ma'am. I do.
Okay, so I'm happy
All
to
right,
give you.
so Judge, I can go
Yes.
get him, and we can, when I come back, we can do a breakout session.
Okay, that sounds good. Okay,
And
is that
then-
fine with you, Ms. McLeod?
That is fine, Your Honor.
And
Okay.
then after we do Bradbury case, I can go get position 23. That'd be the last one for me.
Okay, all right, thank you. So
That's fine.
we're waiting on medical, and we're waiting on South Annex, and we're waiting on to see if we have an interpreter.
I was told earlier that Mr. Brady was in medical, I believe, Your Honor.
Okay.
I am not sure.
I'll ask him when he gets back about Mr. Brady, okay?
Thank you, Your Honor.
And Your Honor, we're also waiting to see if there's a possibility that position 34, Mr. Tillman, could be dealt with by cell phone.
Right, we're waiting for him also. So until someone comes back, we'll be in recess. Mr. Finley.
Yes, Judge.
Apparently a sign language interpreter was not requested. So it appears that we're gonna have to reset that for Thursday, if that's,
Okay, let's see, I emailed.
yeah.
Oh, okay.
Not on your end. It's
Got it,
not,
okay.
nothing that you did wrong.
Okay, no worries.
Okay, so is that all right with you to reset it until the 16th?
Yes, sir. Yes, sir. That sounds like a plan.
Okay, all right. And do we have anyone on from probation? I know we have one probation revocation case, if we can take that up.
Oh,
I'm trying to locate them. Give me a second.
wait,
Okay.
sorry, you cut off for a second. Did you say probation case, Judge?
Yeah, I have a one probation case.
So
Yeah.
I did, I reached out to Officer Middleton and hold on, let me just pull up her message. She said that he's not supposed to be there. He paid his case off and we did a dismissal. I'm not sure, that's what. she said.
Okay.
Yeah. That's what, yeah, I reached out to her about 9 a.m. That's what she said.
Okay, thank you, Mr. Finley. I'll make a note of that. Okay, which? Position 16 and 17, Mr. Hicks, is that also your case, Mr. Finley?
Your Honor, on those positions 16 and 17, I have them here. So they just need to get interviewed. I just brought them.
Yeah, I will need to speak with them. Both of them were in quarantine, so I was unable to see them.
But
Okay.
they're good.
They're good now, okay.
All right, so Mr. Finley is going to need to speak with both of those people before we take them. So
Okay.
do you want to, would it be easier to call or to do a breakout room, Mr. Finley?
Officer Milne, you want to just have them call me or?
Yes, not a problem.
Okay. All right. Thank you very much, ma'am.
You're welcome.
Whenever you're ready, Your Honor, we have Mr. Tillman.
Okay, and what position is Mr. Tillman?
Your Honor, 34.
34, okay. So, yeah, okay, so I don't see Mr. Tillman on camera.
How you doing, y'all?
I'm doing fine, Mr. Tillman. Where are you?
How you doing, y'all?
Yeah.
Okay,
There
okay.
he is.
All right. Mr. Tillman, can you hear me okay? Mr. Tillman,
Yes, sir, I can.
all right, can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
We're holding your case, oh, you can put your hand down, Mr. Tillman. We're holding your case by video. Do you agree to have your case heard by video?
Yes, sir.
Okay, thank you. Ms. Mitchell?
Yes, Your Honor, our recommendation is time served, 15 days, balance suspended, and a stay away from MARTA. 34 was a NOLO issue. The defendant does have 14 cycles and a DUI arrest in 2014, so we do object to the NOLO in this case.
Okay.
Wait, this
Does
is-
he have any similar charges, Ms. Mitchell?
This is for,
Position?
actually, Your Honor, I may have misread. I thought this was a DUI case. We're fine with a NOLO in this case. He didn't have a prior NOLO.
Okay, all right, so there's not an objection to a NOLO, Mr. Ford, or anything further?
No, we concur with the state's recommendation, Your Honor. And
All right. Mr. Tillman, it's my understanding that you wish to plead NOLO in case 22 CR 0034445H to certain acts on a bus, rail station prohibited and obstruction of a law enforcement officer. Is that correct? Can you hear me, Mr. Tillman? Mr. Okay, the reception's not great. Did you hear what I said, Mr. Tillman?
look like he's frozen. Some-
Yes, Your Honor. Yes, Your Honor, I can hear you, Your Honor.
Say it again?
Yes, Your Honor, yes, I did.
Okay, all right. It's my, okay, oh,
Oh, there you
we're gonna
go.
have to try to get better reception. Can you hear me now, Mr. Tillman? Can you hear me now, Mr. Tillman? Okay, well, we can't make out what he's saying.
I can hear you. Yes, I can hear you. I can hear you loud and clear. Yes, Your Honor, I can hear you.
Okay, so you wish to plead NOLO?
Yes,
to-
I can hear you loud and clear, Your Honor.
Okay, well, now that you can hear me, maybe you can answer my question. Do you wish to plead NOLO to certain acts on a bus or rail station prohibited and obstruction of a law enforcement officer?
I can hear you loud and clear, Your Honor. Yes, Your Honor.
Okay, so you
Yes,
wish,
Your Honor.
Okay, Mr. Tillman, I think he has it. Okay.
are you under the influence of any drugs or alcohol this morning?
Yes, Your Honor, I do.
Okay, well, I don't think you heard my question, Mr. Tillman. Are you under the influence of any drugs or alcohol?
think it's frozen.
I'm saying it.
You were saying what, Mr. Tillman?
No, Your Honor, I'm not.
Okay, very good. You've been represented by counsel. Are you satisfied with his representation? Are you happy with Mr. Ford's representation, Mr. Tillman?
No, I'm not. No, I'm not. No, Your Honor.
I don't think he can get more adamant than that, Mr. Ford, but I think that he's responded to the wrong question.
Seems like they've moved them to another area.
Okay, are you back with me, Mr. Tillman? Can you hear me
Yes,
now?
Your Honor, I am.
Can you hear me now?
Yes, Your Honor.
Okay, so you can hear me, but I can't hear you very good. The last question I asked is, are you satisfied with Mr. Ford's representation?
Yes, yes,
Okay.
yes, I am.
You have a right to a trial by jury, and by pleading nolo, you're giving up your right to a trial by jury. You understand that?
Yes, I do.
Has anybody forced you to plead nolo?
Yes, I do. No, sir.
Okay, nobody's forced you to plead nolo?
No, sir.
Okay, I'll accept your nolo, please.
No,
I'll accept your nolo, please, Mr. Tillman. It's time served plea, and you just abide by any active stay away from order, okay? Good luck to you, sir. All right. We appreciate that. Thank you for accommodating us today.
Yes. I'd like to thank the jail for working that out. I really appreciate it.
No worries. No worries.
All right.
All right. Who do we have in medical now?
Norris, Bradbury on 1 North. In front of you at position 23.
23?
Yeah.
Okay. And this is Mr. Mitchell.
Yes.
Good afternoon, Mr. Mitchell. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes.
Thank you. Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you. You can put your hand down. Thank you, Mr. Mitchell. Ms. Mitchell?
This is going to be a time served plea, 365 days, ballot suspended, a stay away from James Hilton's residence at 95 Stewart Drive, Sandy Springs, and his vehicle that was damaged.
Your Honor, my apologies. We were asking if he did qualify for a nolo, that he take this plea as a nolo. I apologize.
What's his history?
I'm going to have to check that, Your Honor. One moment.
Ms. Harrison?
5 cycles.
How many?
5.
Okay.
Oh, no, I'm sorry. This one is 7. It's 7 cycles,
Okay.
but no convictions are indicated on his cycles.
All right, I'll allow him to plead nolo.
Thank you, Your Honor.
Anything further? If not, Mr. Mitchell, it's my understanding that you wish to plead nolo to criminal trespass. Is that correct?
Yes.
Are you under the influence of any drugs or alcohol this afternoon?
No.
You've been represented by counsel. Are you satisfied with your counsel's representation?
Yeah.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury? You don't want a jury trial, do you, Mr. Mitchell?
No, sir.
Has anybody forced you to plead nolo?
No, sir.
Okay, I'll accept the plea as negotiated. Good luck to you, Mr. Mitchell.
Okay. So Judge, what we gonna do about the position for the sign language interpreter?
We're gonna have to reset that until the 16th, till
Okay.
Thursday.
And Bradbury is on a whole different floor from where I'm at. So give me another 10 minutes.
Okay, thank you.
And Judge, I am ready on the 2 at South Annex.
Okay. Right now, we have before you is position 36 and 37.
And what are we doing, Mr. Finley?
Those are my cases, 36.
Oh, I'm sorry.
It's okay.
Mr. Ford?
It's kind of interesting, Your Honor. We are asking for a NOLO on 36. And the only other issue is we're asking for no further violent contact on both cases.
Okay. Good afternoon, Ms. Ramirez. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Can you raise your right hand for me?
Yes,
Do
sir.
you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can put your hand down. Thank you, ma'am. Ms. Mitchell?
Yes, Your Honor, as for position 36, the state's recommendation is 12 months to serve, 22 days, credit for time served, 11 days, balance probated, no further contact with Douglas Favors.
Oh, no.
Well, hold on, Ms. Ramirez.
This Mr. Favors? Okay, just to let you know, Mr. Favors is in court with me, and if he desires to speak in regards to this matter, I'll allow him to do that at the appropriate time, okay? All right, you continue, Ms. Mitchell.
A 6-week anger management course and no alcohol, drugs, and weapons. In this case, officers heard loud talking and profanity coming from the parking area of 901 Rice Street, Atlanta, Georgia. The officer exited the building and found the defendant battering Mr. Favors by striking him repeatedly about the head and facial area. When given verbal commands to put her hands behind her back, the defendant refused and resisted arrest. As to position 37, the state's recommendation is time served, balance suspended. No further contact with Mr. Favors. In that case, the defendant criminally trespassed against Mr. Favors' property by breaking the glass window and mailbox at their residence on 1558 Deauville. Deauville, spelled Deauville Court, Northwest Atlanta, Georgia. That was in 2019, so I'm not sure if that's still the address, but being that these are 2 cases that involve the same victim, Mr. Favors, we are objecting to the no further violent contact. The defendant does have a cycle of 35 cycles. She has a simple battery and damage to property in 2021 where the disposition is unclear. She has a criminal trespass arrest in 2019, criminal trespass arrest in 2018, a simple battery, family violence arrest, and 2 counts of battery arrest in 2018, and then a criminal trespass in 2011. She also has, as far as conviction goes, I mean, she is a convicted felon, but as far as violent offenses go, she has a simple battery in 2006 and a robbery in 2006. The others are drug and theft related. So based on that, we will also object to the NOLO. No, thank you.
Okay. Mr. Ford?
Thank you. If Your Honor, if Mr. Favors is in wants to speak, I'd like for him to speak at this time, if that's a possibility.
Okay, if you can come up to the microphone.
Yeah, sir.
I'm doing well, Mr. Favors. How are you?
Yes, sir.
Yes, come on. Can you raise your right hand for me?
Yes, sir.
Do you swear affirm the testimony you're about to give before this court will be the truth, the whole truth, and nothing but the
Yes,
truth?
yes, sir.
Okay, you can put your hand down, Mr. Favors. What would you like to tell the court?
I like to say that she's a good person. We both had gone around and I want to know that could you get a chance, let her give her that chance to do the right thing.
Okay,
I work at the jail. I've been there like 20 years.
you work where?
Hey, Rice Street, been there 20 years.
Okay, and how do you know Ms. Ramirez?
I met her in the neighborhood.
Okay. And
Yeah, we've been together for almost like 7 years.
okay,
She stayed with me. I have proof to let you know she stayed with me. I got everything of
okay,
when she paid for light bill and all. I got everything I need right here.
okay. So you all live together?
Yes, sir. We live together right now.
Are you afraid of her?
No, I love her.
Okay, and these charges happened back in 2020. Has anything happened since that time?
No, ain't nothing happened.
Okay,
She there for me and I'm there for her. That's why I'm here now.
okay, all right. Thank you, Mr. Favors. I appreciate anything else you want to tell?
I'd like to tell you that could you please give her another chance?
Okay,
And I seen they had a program. I'd like for her to get into that program. And whatever I need to take, I'll be there for her.
okay. All right. Thank you, Mr. Favors.
Thank you, sir.
Mr. Ford?
Thank you, Your Honor. Yeah, I just want to say, you know how vehemently I oppose anger management for my clients. But when I talked to Ms. Ramirez about having the anger management taken away, she said no. She understands that she wants to get some more training on dealing with certain issues that come up, Your Honor, and I really respected that. I wanted to let the court know that we're not going to object to the anger management. As you've heard from Mr. Favors, they've been together for a number of years. That's why we're asking for no further violent contact. I think Ms. Ramirez tried to say something about when you said no further contact, but Mr. Favors and her really support each other. So I'm glad that Mr. Favors did come forward. She was very proud. She's raised 16 kids, 16 children. And the fact that I found that was even more impressive, she has 68 grandchildren. And so she's needed to out there to help support her children, help support her grandchildren, help to support Mr. Favors. I know this is a time served deal, but she understands that the anger management, she wants to just go ahead and get more help and try to understand when situations arise. So I'm asking that you accept the time served deal and then ask that you give her a NOLO for position 36, and she's prepared to plead guilty on position 37.
Anything further, Ms. Mitchell?
No, Your Honor, the state still objects to the NOLO and the no further contact. Nothing further.
Okay. Given her history, Mr. Ford, I'm also being told that she does have another open case for simple battery and damage to property. It's a 21 CP 202848 case. As such, I will accept a guilty plea from her on these charges, and I think that was the only thing that you were requesting. Is that correct?
No further violent contact, Your Honor.
Oh, and no further violent contact with Mr. Favors. Okay.
All right, Ms. Ramirez, the judge is saying that you can have contact but no violent contact with Mr. Favors. You understand that? Is that yes?
You're on mute, South Annex.
Is that a yes, Ms. Ms. Ramirez?
Yes, sir.
You understand that you have time served, so, but you have another case that you have to deal with.
Yes,
Okay, and so
Okay.
you have to plead guilty to both cases. Are you prepared to do that?
yes, sir. The other case was concerning, the case you're talking about with my nephew, is that?
Okay,
done?
hold on. I don't think you need to speak about that case right now, even though I'm not representing you on that case, Ms. Ramirez. I think.
Do I have to, because someone switched my address in the.
Oh, whoa, Miss.
Okay, what I'm
We're
trying
just
to find
gonna
out.
deal with we'll just deal with 36 of the two cases today, okay? All right?
Okay, that's cool.
All right,
That's
all
cool.
right. Thank you. We're prepared to move forward, Your Honor.
Okay. Ms. Ramirez, it's my understanding that case 21 CR 004657Y, you wish to plead guilty to simple battery, disorderly conduct, and willful obstruction of a law enforcement officer. And in case 19 CR 009429Y, you wish to plead guilty to 2 counts of criminal trespass. Is that correct?
Yes,
Are you under the influence of any drugs or alcohol this
No.
afternoon? You've been
No.
represented by counsel. Are you satisfied with your counsel's representation?
yes,
You understand that you have a right to a trial by jury on these charges and that by pleading guilty to them, you're giving up your right to a trial by jury?
yes, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
I will accept the guilty pleas for position 36. It's going to be 12 months to serve, 22 days, credit for time served, 11 days, balance probated, no further violent contact with Douglas Favors, a 6-week anger management course, and no alcohol, drugs, or weapons while on probation. In position 7, it will be 12 for each charge, 12 months to serve, 22 days, credit for time served, 11 days, balance suspended. I'm going to waive the probation fees for you while you're on probation, Ms. Ramirez, to help you get and stay on your feet. And when you complete the terms of the probation, it will go to a non-reporting status, okay?
Yes, sir.
All right, good luck to you, Ms. Ramirez.
You too. Thank you, Your Honor.
You're welcome.
Thank you, Attorney. Thank you all. Hey, Doug, I love you.
And thank you, and good luck to you, Ms. Ramirez.
All right. Next, we have
Thank you,
position
Mr. Favors.
Ms. Hicks.
Is it about this matter? Okay, you'll have to come back up to the podium. Before we move on, Mr. Favors has something that he needs to say. Does it concern this case, sir? Okay, well, we've already, she's getting time served, so, and you're. There's no bond, so there's nothing for you to pay, okay?
Okay, it's good. You're good.
Yeah, as soon as she can get processed out, she'll be out. You're welcome. Have a good day. Okay, I'm sorry. Tell me again who we have.
Position 16, Ms. Hicks.
Okay. What are we doing with Ms. Hicks, Mr. Finley?
Yes, Judge, this is a negotiated plea.
Okay. Good afternoon, Ms. Hicks. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can put your hand down. Thank you, ma'am. Ms. Tortorella?
Yes, Your Honor. This defendant's being charged with loitering and prowling, and the state's moving forward with said charge. The offer is 12 months served, 20 days, credit for time served, 11 days, balance probated, 40 hours of community service, and that she stay away from the MARTA station at 770 Hamilton East Holmes Drive, Northwest in Atlanta. Nothing further.
Mr. Finley?
Yes, Judge, and that is our understanding of the offer, of which we do agree. And we would just ask on behalf of Ms. Hicks that once she does complete that community service, that the balance of her probation could either be suspended or be non-reporting, Judge.
Okay. Ms. Hicks, it's my understanding that you wish to plead guilty to loitering and prowling. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this afternoon?
No, sir.
You've been represented by counsel. Are you satisfied with his representation?
Yes, just the probation part, yeah.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
I will accept the plea as negotiated, Ms. Hicks. I'm going to waive your fees while you're on probation, and when you complete the terms, the probation is going to terminate, okay?
Thank you.
You're welcome. Have a good day, ma'am.
Next, we have position 17, Ms. Irving.
What's the announcement, Mr. Finley?
Yes, Judge. This is going to be a bond hearing.
Okay, and the arraignment?
Yes, Judge. Yes, sir.
Good afternoon, Ms. Irvin. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video? Is that a
Yes.
Okay. Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Okay, you can put your hand down. Thank you, Ms. Irving. You've been charged in case 22 CR 003391A with battery, criminal trespass, and possession of marijuana less than an ounce. Each of these charges carries with it a maximum penalty of 12 months in jail and or $1,000 fine. Do you waive formal reading of the accusation, Mr. Finley?
I do.
How do you plead to these charges, Ms. Irving? Guilty or not guilty?
Not guilty for the battery.
Okay, well,
And the,
Ma'am, so yeah, when we spoke, we talked about all three, and they're all together that you wanted to plead not
Space.
guilty.
May I see the bond in this case? So you're pleading not guilty to all three charges, is that correct? Ms. Irving?
I was assaulted by the staff, the security. They escorted.
Ms. Irving, you have a right to remain silent. Anything you say can and will be used against you, okay? So I would suggest that you let Mr. Finley represent you in this matter and speak on your behalf. My only and last question to you was, as far as the battery, the criminal trespass, and the possession of marijuana less than an ounce, do you plead guilty or not guilty to these charges?
Not guilty.
Okay, we'll record your not guilty plea. Your case will be returned to the division judge, and you'll get notification of your next hearing date. I've got that there's a split bond in the case, a $500 good bond for the battery and a $500 signature bond for the possession. And I don't see that there is a bond set on the criminal trespass. Is there a bond on the criminal trespass?
No, Your Honor, that was added.
Okay.
So she will have to, we'd have to give her bond for that one. And if Your Honor, I was just wondering if we could break out, I wanted to break out with the public defender and yourself. I would like to discuss something that I do not want on the record.
Okay, so we'll go into a breakout room with Mr. Finley, Ms. Tortorello, Ms. McCutcheon, if she desires. Anyone else? Okay, Ms. Champion.
Because I have to take you off, I can get ready for my next court.
Okay, Ms. Irving, we've considered bond in this matter. You're going to get a signature, a $500 signature bond through the jail on each of these charges. But I'm going to require that that you stay on any prescribed medication. If you're on any medication, that you take it as prescribed and that you comply with any kind of current medical recommendations that are recommended by your physicians. You have to stay away from the Atlanta Medical Center unless you are seeking emergency treatment there. You have no alcohol or drugs or firearms while out on bond. And I don't know if you even know the complaining witness, but no further contact with Miss Nashana Bennett. Okay, so you'll be able to sign yourself out and to come back and to face these charges at a later date. Okay. All right. Good luck to you, ma'am. Okay.
Your Honor.
All right. I'll see you this afternoon.
Oh, no, hopefully not,
Okay.
because I don't have anybody on the calendar.
Okay. Very good. All right.
All
Thank
right.
you.
You're welcome. See you guys next time.
Hold on one second. Okay, no, I think so. I think we have someone else coming back from medical. So thank you.
Right. You're welcome.
Thank you.
Bye-bye.
Let's see, while we're waiting, I don't think medical's back with us yet. Ms. Grace, can we go over the calendar? Okay. Is that all right with everyone if we go over the calendar while we wait?
That's no problem, Your Honor. Is there any way for you to indicate, so I just want to make sure my records match, that which ones were NOLO and which one were just straight guilty plea?
Miss Grace can't do that, but I will go from my calendar when she makes her announcement, and I will give you what I have from my calendar.
All right,
Okay?
thank you very much, Your Honor.
If you wouldn't ask for so many NOLOs, Mr. Ford, we wouldn't have.
I just don't want you to forget me. I haven't been here so long, so this is just.
I always know when you come here, Mr. Ford, because I have to deal with NOLOs.
And Mr. Ford, the state did not say that. Just be on note. That was not the state's comment, but the state was thinking that. Thank you.
I expect the state just to give me NOLOs when I show up. But no.
Right, but it's Charles Nolo Ford. All right.
I resemble that statement.
It's been a long morning. I'm sorry. Whenever you're ready, Miss Grace. Okay, she's ready.
Position number 1 was a plea. Position number 2 is a plea. Position 3 was
Unable to hear.
reset further numbers. Position 3.
I'm sorry,
Hey,
Judge,
sorry.
I can't hear her.
Oh, they can't hear you. Okay.
Position number 1, can you guys hear me now?
Can you hear her now?
No.
Okay. You know
Very
what?
faintly.
Okay, so why don't I do this? Why don't I just go from my calendar? Okay? I'll go over the calendar. If you can turn your volume down. Okay. So you go along with me, Ms. Grace, and, okay. Position 1, I have a plea. Position 2, I have a plea. Position 3 was released. Position 4 was reset until Thursday, 6/16. Position 5 was arraigned and not guilty. Position 6, I have was reset to 6/21. Position 7 was a plea. Position 8 was arraigned. Position 9 was a plea. Position 10 was arraigned. Position 11, I think we're waiting on. Position 12 was a plea. Position 13 was a bond hearing. Position 14 was arraigned. Position 15 was a plea. Position 16 was a plea. Position 17 was arraigned. Position 18 was a plea. Position 19 as reset. Apparently he's being loaned out. Do we have a reset date that we want to reset Mr. Johnson until? This is your case, Mr. Finley?
Yeah, if we could just do, sorry, they cut off, which number was this? This 19?
19. Apparently he's loaned out to Cobb County.
I guess maybe Tuesday.
Next week, okay, so that's the 21st, 6/21. Position 20 was released. Position 21 was a plea. Position 22 was a plea. Position 23 was a no-low plea. Position 24 was a no-low plea. Position 25, I have that it needs to be reset for mental health.
Your Honor, you said position 24 was no low? 20 was a no, 23 was a no low. I have that, but 24 I don't have. As
Okay,
a-
but
I have both 23 and 24 as no low.
okay, what do you have, Ms.
Um,
Grace?
I'm sorry?
Oh, you don't have, okay, well, I have them both as no lows. We'll have to check the paperwork. Okay, so I'll make a note. Position 25 is reset mental health, and I think that's on the 16th. Position 26 was a plea. Position 27 was released. Position 28 was a no-low plea. Position 29 was a plea. Position 30 was a no-low plea. Position 31 was a plea. Position 32 was a no-low plea. Position 33 was a plea. Position 34, no-low plea. Position 35 was a plea. Position 36 was a plea. Position 37 was a plea. Position 38 was released. On the add-on calendar, we're waiting on position 1. We're waiting on position 2 and 3. Position 4 was arraigned. Position 5, 6, 7, and 8 were pleas. Okay, and we'll check the paperwork on position 24.
Yes,
Any
that was the thefts. That was the theft case, and he had 33 cycles with the history of thefts.
Which one?
Position 24.
But I have it down as a no low. So does the judge.
Well,
And
24 is not the theft one. That's 22.
Yeah, because 24 was the was just a murder, was the criminal trespass.
Right.
And
Right.
23 was the criminal trespass. So both of those were no low.
I'm being told that it was a no-low plea.
Right. My apologies.
Okay, no worries. Anything else?
Let's see, so you said we were waiting on position 11? Is that what you said?
Yes.
So I apologize that I didn't mention this earlier. So I was unable, well, unable to talk with Miss Craig. I'm gonna have a social worker, go speak to her. So that's gonna,
So you want to reset that until when, Mr. Finley?
um, see if we could reset that till maybe the 23rd.
So the
23rd.
Thursday after next?
Yeah, let's just do that to make sure someone sees her. Because I've had to reset her a couple times and have been unable to communicate with her. So I'm gonna have a social worker go see her.
Okay, so we reset her for 6/23. So that means that we are waiting on the add-on calendar positions 1 and 2, which I believe are that they're getting for us.
And then one more thing, Mr. Coleman, he wants to be put on another upcoming calendar to reconsider his plea that he didn't take today. Or should I just email Mr. Jordan?
What position is he?
Coleman was, he was position 8. And he, yeah, we did a bond hearing for him, but he, one of the officers called me and said that he wanted to.
Okay,
reconsider.
when would you like to put him on?
If we could do a week from today.
Okay, so 6/21, we'll make a note. Who do we have in courtroom 2?
Bradbury.
Bradbury. And you're gonna need to speak with him, is that correct? Ms.
I
McLeod?
do, Your Honor. I still haven't spoken with him yet.
Okay, and have you
I was
gotten?
told that I'd be put in a breakout room to speak with him and Mr. Brady.
Okay, do you have Mr. Brady there also, courtroom 2?
No, the other officer that was doing 5, he on the 5th floor, he was in control of that. I had medical.
Okay, so I just want to let you know, so we have Mr. Bradbury here. We're also gonna need Mr. Brady, who's position 2 on the add-on calendar. So we'll deal with Mr. Bradbury now. Can we put courtroom 2 and Ms. McLeod into a breakout room, or would you like to call Ms. McLeod? Which would you prefer to do?
I'll do whichever is convenient to him.
Breakout room?
Yes.
Okay, so if we can put Ms. McLeod and courtroom 2 into a breakout room, please.
Thank you. Thank you.
You're welcome. And we'll be in recess. And did you have something, Mr. Finley?
Yeah, Judge, I apologize. For Mr. Coleman, it actually was time served. Is it possible that he could be, I know the calendar was already sent out for Thursday. Could he be an add-on? Or if not, we could do Tuesday then.
So you wanted to do an add-on for the 16th?
Yeah, if we could, because yeah, he is a time served. So yeah, I want to try to get him out.
Okay, we'll put him on the add-on calendar on Thursday.
Thanks, Judge Morrow.
Okay. Okay, we'll be in recess until someone returns. Were you able to speak with him?
I was, Your Honor. I was able to speak with my client.
We're, so what's the announcement?
Hey, Judge, before we start on Bradbury, the announcement for Eric Brady that he went to prison.
Okay, so he's not there.
Oh.
Okay.
Oh, his mom just called, Your Honor, and I told you, okay. I think she's on the Zoom, so she probably heard that. I was not aware of that, Your Honor.
Okay, so he won't be available today. And so what are we doing with Mr. Bradbury?
He's going to take the plea, Your Honor.
Okay. Good afternoon, Mr. Bradbury. I'm Judge Eric Morrow. This is the state all-purpose calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, Mr. Judge.
Thank you. Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, Judge.
Okay, you can put your hand down. Thank you, Mr. Bradbury. Ms. Tortorella?
Yes, Your Honor. This defendant's being charged with simple battery, and the state's moving forward with said charge. The offer is 12 months, serve 52 days, credit for time served 27 days, balance probated, no further contact with the victim, and her name is Kieta Butire. It's spelled K-I-E-T as in Tom A. The last name is B as in boy, O-U-T as in Tom, I-R-E, that he stay away from the incident location, which is the liquor store at 4155 Fulton Industrial Boulevard, Southwest in Atlanta, and an 8-week anger management classes, nothing further.
Ms. McLeod?
Yes, Your Honor. My client tells me that he did not know these people at all. And they attacked him. However, he is willing to take the plea, Your Honor. He doesn't have any money for probation fees because he has been locked up for almost a month already. But otherwise, he's fine with the anger management and with the other terms.
All right. Mr. Bradbury, it's my understanding that you wish to plead guilty to simple battery. Is that correct?
Yes, Judge.
Are you under the influence of any drugs or alcohol this afternoon?
No, Judge.
You've been represented by counsel. Are you satisfied with her representation?
Yes, Judge.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes, Judge.
Has anyone forced or coerced you to plead guilty?
No, Judge.
I'll accept your guilty plea, Mr. Bradbury. I am going to waive the probation fees for you while you're on probation and help you get and stay on your feet. And when you complete the terms of the probation, it'll go to a non-reporting status, okay?
Yes, Judge.
All right, good luck to you, Mr.
So how many
Bradbury.
days I got left, Judge?
I believe it's a time served plea, so when they can process you out, Mr. Bradbury, you'll be getting out, okay?
Okay, I did. It's time served.
Yes, sir.
Okay, thank you, Judge.
You're welcome. Have a good
Mr.
day.
Bradbury, could you ask the courtroom to just send me your contact information in the chat?
Yes, ma'am.
Thank you.
Okay. All right, so I think that completes the 9 o'clock calendar. If you all will go ahead and get your paperwork to Ms. Grace so that we can get that signed. And otherwise, I hope you all have a good rest of the day.
Thank you, Your Honor.
Thank you, Your Honor.
Thank
Okay.
you.
Thank you, Judge. Thank you.
Thank you, Your Honor.